Yeah. Okay.
As you know, that's disclosed subject to undertaking not to be used for collateral purposes. Purposes of this appeal.
Is that your report? Oh, the creditors are in charge of the truth.
Well, if you want to apply for PLC civil affairs, that's fine, but we don't need to be accredited. So it's being circulated as an appeal, the subject to undertaking not to be used for collateral purposes.
Good afternoon, everyone. The court has reconvened for the hearing of Petrochemicals Limited and Sino International Limited. The appearances are as before. Mr. White.
My Lord, in terms of using my time this afternoon, I intend firstly to deal with some residual points on the grounds of appeal.
Yes.
And then I'll move on to the potential scenario identified by the court at the end of yesterday afternoon. My Lord, one small point to start with. In relation to the evidence of Mr. Lai and his second affirmation, I had taken you to the 2016 annual report. And the point in question we were looking at was the issue that Mr. Lai had started, a starting proposition, as it were, in his evidence, the title was tax rich
Yeah.
in 2017. So I took you to the 2016 annual report. My lords, I should also take you to the relevant figures for 2017.
Right.
If I can ask you to get a bundle, it's E1, it's tab 43, and page 620, 43. My lords, if you look towards the middle page, slightly faded on my copy, but it's the second paragraph. It says, the group financed its operation mainly through the loans from the ultimate holding company, banks and other independent third parties in Hong Kong and mainland China. And as at 31st of December 2018, the group had cash and bank balances of Hong Kong 11.3 billion. And then it says, as at the 31st of December 2017, there was cash and bank balances of Hong Kong 83.4 billion. My lord, 2 points arise from this. Firstly, self-evident point from the first text I draw your attention to, which was that the group was being financed by loans from the parent company, so tightening the same.
But remind us what they're comparing numbers were for 2016.
My lord, it may take a moment to find out. I don't have time. If perhaps by the end of my submission, I'll give you the rest.
Presumably, after the exercise is to show that the position deteriorated in some fashion.
My lord, the point is this: the loan is 78 million Hong Kong dollars. The loan was made in 2017. The amount of cash that was left at the end of 2017 was only 5 million. Sorry,
That's simply to show that it could not be.
well, it couldn't do both because it wanted to expand. And we saw the minutes yesterday where various amounts are being spent. For instance, the investment into the Sino shipyard, Asia Pacific, a company that provided funding in the shipbuilding industry, and also some 20 million Hong Kong dollars spent on salaries, etc., immediate payments of Titan. So you can't have both things. You can't have working capital and expansion, because if the money had not been borrowed and just the funds of Titan being used, then there would only be about $5 million left at the end of that year.
Sorry, can I just make sure I've got these figures right? This is the 2018 report.
My lord, yes, but the figure given in the brackets is the figure for 31st December 2017, which shows us 83.4 million.
You didn't have it.
Started off by reference 2016, but this is 2017.
My lord, of course, the 2018 report looks back to 2017 and so forth.
So wait a minute. As at December 17, 31st of December 17, the net assets were 246.7 million. Slightly, and in December 2018, they were 2,243 million Hong Kong. So, wait a minute. So they very much increased. Wait a minute. No.
Why did they say December 2018?
This is the 2008.
Well, no, it's the 2018 report that looks back on 2017, but the figures I'm drawing your attention to are pretty marked for the cash as at 31st of December 2017.
Well, yes, sorry, I can only take one thing at a time. The position was that on 31st of December 2017, there were net assets of 246 million. A year later, December 2018, there were net liabilities of 2,000 odd million. Is that right? Am I reading this correctly? Yeah. So things got much worse. Then the figures to which you would direct our attention below is that as at the cash balances, as at the 31st of December, were 83.4 million Hong Kong. So only just above the 78 million of the bond.
My lord, yes.
Right. Okay.
My lords, to make this point really clear, if look in our high skeleton, which is find the G-tab form, and go to page 128, G.
Yes. What page of this skeleton itself?
Yes,
The flag
it's the
skeleton. I see.
Respondents reply skeleton, page 128. And my lords, paragraph 10.4. And my lords, perhaps if I give you just a moment to read that paragraph, which may explain the point.
Okay, if you want us to read it, stop speaking.
My lord, yes.
Yes. Yeah, I follow.
Well, I hope that point is now clear. I think it's probably better writing than I presented it in those oral submissions. To move on to the balance of the respondent submissions on the grounds of appeal.
Yes.
One of the issues my learned friends referred to both in written and oral submissions is the issue of the post-petition disposals. And by that I mean the 6 transactions that took place, 5 in December 2019, between the 6th and 15th of December, and the other one involving Titan Fee 1, which occurs in July of 2021.
Yes.
My lord, that goes to ground 2.2.2 of the grounds of appeal. And what is said by Titan is that the judge was wrong to conclude that Titan had entered into a number of questionable transactions to entities potentially related to either Mr. Zhang and his father, including the apparent disposal of assets at undervalue. And my lord, implicit, it seems, within that ground is the suggestion that the learned judge below has made a finding of fact. My lord, we'll look at that part of the ruling in a moment. My submission is this: there is no finding of fact by the judge. The judge didn't need to make a finding of fact. Nobody invited him to, and it wouldn't have been appropriate to.
So what? Well, I was slightly puzzled by this approach. You put in a lot of prejudicial evidence. The judge takes it into account, and you say, we didn't make a finding of fact. But you obviously relied on it.
Well, yes. If we're in a situation where it's analogous to a summary judgment application, where we're looking at the threshold test, the judge can take into account all the various circumstances of the case. And when we look at the post-petition disposals, they've raised, and I'll come to Mr. Zhu's evidence in a moment. They were raised.
Just interrupting you, I'm afraid. Paragraph 70 deals with the transactions which Mr. Howard had brought to the attention of the court. But she does carry straight on and says 71. In the circumstances, it is reasonably clear from the evidence before the court that ABCDEFP. So, are those findings of fact?
My lord, if we go to paragraph 70, it said the company embarked on wholesale disposal of its most significant assets for nominal consideration. Now, in terms of that, there's no dispute from the company. Firstly, the assets have been disposed of, and secondly, their values, because each of the assets was subject to a disposal notice on the Hong Kong Stock Exchange. And again, the petitioner has no special knowledge on this. The petitioner has looked at what's been published by the company and raises the question, well, okay, you're selling an asset for, say, 10,000 Hong Kong dollars, which is approximately 1,200 US dollars, so relative peanuts. And you're doing it after the petition has been presented. And of course, whilst the court is gearing up to hear this dispute, because we have 5 disposals in December 2018 for approximately $6,000 in fee. And my lord, when we come to the next part of the judgment, it says to entities potentially connected with Mr. Zhang and his father. And then there's a reference to the 7th affirmation of Mr. Zhang. And it says the company has entered into a number of questionable transactions. The entities potentially related to either Mr. Zhang and his father, including the apparent disposal of assets at undervalue. My lord, these are not phrases used for finding the fact. They reflect the careful way it was posed by Mr. Zhu, because the petitioner was raising.
Where were you reading from there?
My lord, it's 70, and I was reading from, I think it's the second from the last sentence, set out in the 7th affirmation of Mr. Zhu.
But those are simply the transactions which Mr. Zhao brought to the attention of the court. So there's no question of finding in relation to those.
My lord, no, and no finding was sought by the petitioner. What Mr. Zhu says is the petitioner has concerns, because they do appear prima facie to raise the question. Why on earth is the company doing this during winding up proceedings? And why is it selling what appear to be its significant assets for mere peanuts?
Together are the 6th factor taken into account by the Chief Justice in granting the petition.
They are, because the Chief Justice, and this, the approach that the appellant accepts is that the Chief Justice can look at the question of bona fide substantial dispute based on, it's a question of judgment based on the facts of each case. And I want to remember yesterday we looked at certain issues that can be considered and have been considered in other cases, such as delay, whether further proceedings are retaliatory in nature, and the relevance of the potential insolvency. And we looked at the cases of Rio Company, ex parte Finsol, Mr. Justice Holman's judgment, and also Mr. Justice Hoffman's judgment in re-record 10%. And I thought this is part of the factual matrix.
Or the non-factual matrix, as I understand it, you say it is mainly findings of fact.
I know, yes, but there are a considerable list of reasons why the judge comes to his conclusion. And this is just one part, it's the final part.
Well, yes, but it is part. I mean, let me just try and work out where we've got to. The fact that these transactions took place, that is to say that these 6 dispositions occurred of companies in the group for almost nothing, was, I think, indisputable, because they were all announced to the Hong Kong Stock Exchange. So, in a sense, that was, the judge didn't need to make any findings of fact, because that was so, could not be disputed. What was not accepted was that these were improper transactions because they were disposals of assets at an undervalue. You're right that the judge didn't find that these were disposals of assets at an undervalue. but he relied upon the fact that they appeared to be as part of his reasoning.
My lord, yes, he can look at the factual matrix. In
You're
its
not
judgment,
saying the factual matrix, but the critical question under this heading is whether or not these transactions were at an undervalue.
my lord, this was an issue that went to two issues. One was a bona fides issue.
Yes.
The other was the exercise of discretion. In terms of the bona fides issue, it wasn't a significant issue. It was one of the list of factors, and so it's the final part of the list of factors. It's also dealt with in terms of discretion. My lord, I think it's useful to look at paragraph 86 of the judgment, where the judge says, finally, the court is bound to express its concern at the substantial disposition of the company's property shortly after the petition is filed. For nominal consideration, the company is associated with its design with its father. Having regard to the dispositions of the company's property, identified in paragraph 17 above, it's in the interest of the general body of creditors and the wider public the transfers of property be investigated by independent liquidators appointed by this
So
court.
he stopped short of making a finding in relation to that, but he says that somebody should investigate them.
My lords, that's apparent. It must be of concern, it would be of concern to any judge that a company is disposing of assets after a winding up petition has been presented at such significant numbers for such little money. I mean, one might understand it, for instance, if substantial sums had come from those disposals, which should fund the working capital of the company. But $6,000 is probably a few hours of the Conyers legal team. It gets the company nowhere. I don't need to be glib. It's a very small sum of money. My lord, it does, perhaps using the cliche, cry out for some form of explanation. The judge put it no higher than that. In terms of their attack on the company's attack on appeal on how this is put on the judge, firstly, it seems to be implied it is a finding of fact. Then they argue that these are extraneous and unpleaded matters. Well, they're not extraneous because one looks at the facts of the case, nor are they required to be pleaded because it's not a, you wouldn't plead this in a petition. When the petition was filed, of course, the company hadn't raised a defence, but it admitted to raise its defence in pre-action correspondence. So it's not a pleading point, certainly not extraneous. And it has not been answered by the company. And my lord, the issue of some of these disposals was raised right at the beginning in Mr. Z's first affirmation, where he raises his concerns about some of the December transactions. In the notice of appeal, the company takes an opportunity to respond. So they do so only on one transaction, which is the entitlement for Jean disposal. And it's said within the ground of appeal, this is 2.2.2, that this disposal was subject to strict vetting by the Hong Kong Stock Exchange. Now that is a surprising submission to make a number of. Firstly, it wasn't a point taken. My lord, it's 2.2.2. I don't intend to take you there, but it's pages, it's bundle A, tab 2, 40 to 41. So it's a surprising point. It's not a point taken below the full judge. It's not a point on which evidence was made of what the Hong Kong Stock Exchange does in terms of vetting. And that is the position as it remains on appeal. It's also surprising because one wouldn't expect the stock exchange to carry out vetting the commerciality of a transaction. But the position is now modified in my learned friend Skeleton Hard. My lord, again, for time purposes, I won't take you there, I'll give you the reference. It's paragraph 93A of the appellate skeleton, bundle G, page 30, where it's now said the vetting applied only to the announcement circular and shareholders' approval. And my lords, the problems that come with this transaction, we go back to paragraph 70 in bundle A of the judge's judgment, and this reflects what is said in Mr. Zhu's evidence. It's at F on page 26. Is that this is a significant asset of the company. Now, technically, it's sold for 1 RMB, but the value attributed to it is actually more, because the deal that's done involves the purchaser taking on 160 million RMB of Titan Group's debt. So the true value is going to be 160 million RMB plus, I suppose, more further RMB. And it's said that Mr. Zhu expresses concern at this transaction, given that this amount is even lower than the independent valuation made in 2017, when the land was placed in security put back in the PRC, amounting to RMB 253 million, which is approximately 38 million US dollars. And it's known that land prices in China have significantly increased since that date. So one can see the petitioner's concern. It's valued 2 years before for much of it. The land prices are great, and yet it's valued at 160 million. My lord, if we go to bundle C, there is actually some evidence from Mr. Zhang on this in his first affirmation. And if we go to it's C tab 25 and page 221.
So Mr. Zhang or Mr. Zhu?
Mr. Zhang.
Tab 25.
Tab 25. In fact, if I can ask this on page 218. 24. Tab 24. Sorry, I apologise. Tab 24.
Where are we? Again, just like.
So page 218, and if we look at, I was going to direct your attention to the heading just above paragraph 108. So this is Zhang's first affirmation, filed shortly before the return date of the petition. This is the affirmation where it raises the company's defence. And Mr. Zhang grasped at that stage that the insolvency, financial health or ill health of the company is an issue, because we have this ending edge, current financial status, operation, and the prospects of the country. And my lord, if we turn the page, he deals with a number of subsidiaries of the company. And his tactic here is to say, well, the company prospects are rosier than you would think, because some of the subsidiaries are doing quite well. He mentions OpCo at paragraph 110, but we come to Titan for John at paragraph 118. And he says, besides marine-related business,
Sorry, 120.
18. 118. He says, besides marine-related businesses, Titan Group also has substantial investment in the real estate sector. Titan Petrochemicals Sichuan Limited, a wholly owned subsidiary of Titan, is registered in Quanzhou with a registered paid-up share capital of $30 million. It owns a piece of undeveloped land planned to be used for office and living purposes in Quanzhou. And then we fairly quickly, just again giving another type, paragraph 119, bottom of that paragraph, he makes the statement it's estimated to project site covers an area of, it says 40 MU, I'm not sure what that means in this context, but a floor area ratio of up to 3.5. And is estimated to have an investment, I think that's investment value of RMB 300 million. And below that 120, it's a site of 75,000 square metres, 20,000 square metres of office building, 50,000 square metres of residential buildings, 5,000 square metres of commercial building. And then we go to paragraph 121. And he says the current price of commercial residential houses in the surrounding area is 15,000 RMB per square metre. Since the properties on the project site is indivisible, Titan Fish Lines proposed to sell the use of the right of the above assets at the price of 8,000 RMB per square metre. And he says they can pre-sell them. And looking at the 20,000 square metres of office space, TfL can recover 160 million RMB if you're using 8,000 RMB per square metre. And the reason why I'm throwing out these figures is because straight away, a small part of the development is worth 160 million. Now, residential property is worth 15,000 per square metre, as opposed to 8,000 per square metre. But if we just use the lower figure of 8,000 and times it by 75,000 square metres, total site, the value here is 600 million RMB. And this is sold in 2021 for 160 million. Now, the company may have forgotten about their efforts because they early received and to make a very different point. The point Mr. Zhang is making is, look, there's this great asset, which is worth an awful lot of money. That turns out not to be the case because it's sold what seems to be money. And to pay off loans taken on by the company in 2017.
Sorry, you got 600 million by multiplying 75,000
by 8,000.
8,000.
As I said, I've taken a fairly crude approach to it because some of it would be worth 15,000.
50,000 square metres of residential. So presumably the other 25 comes somewhere.
My lord, it says, sorry, I put it away. It says in the preceding paragraph, the total site is 75,000 square metres.
Yes, but there are different values for residential and commercial.
My lord, yes. So to take the Ferris approach, I've taken the lowest value. I could have times 50,000 by 50,000 RMB per square metre. But I think that's probably, I think I can make my point about it. It's a fraud.
Is the RMB and the Hong Kong dollar broadly equivalent?
My lord, I don't know. I suspect there is a difference.
Yeah.
Perhaps we could clarify that point for you.
No, don't worry.
And the other factor that comes out of that, which may pique your attention, is the fact that Mr. Zhang himself confirms that at the date of the petition, Titan Fish One is a directly held asset of Titan Petrochemicals, so the company. And by operation of section 166(1) of the Bermuda Companies Act, if disposal is made of an asset of the company, post presentation of the petition, it is automatically void.
It's not correct. If a winding up order is made.
Sorry, where's Mr. Zhang's confirmation?
My lord, sorry, what was the?
Where is Mr. Zhang's confirmation?
Of that fact.
It was, my lord, it was paragraph 118, the first. I took you to paragraph 118 and read the section. It's a wholly owned subsidiary of Titan.
And sorry, what is the section that you say is
Section 166(1).
the Companies Act? Yeah.
My lord, the effect of that is, so any disposal made post presentation of the petition, if a winding up order is made by the court, it will be void. So if you make a disposal, the approach is to seek the validation of the court. Now you can do that after the event, you do it retrospectively, but of course that's quite a dangerous approach to take. And we're told by the appellant that the court can take faith in this being a board stacked with independent professionals, and the court can take their own view on that. The fact that no validation application has been made, because the point of the winding up order, which of course has been made, is that that is void. It's a risky business. And my lord, I can't take the point any further than that, but if you make a validation application, of course you have to set out all the nuts and bolts of the transaction and provide disclosure to the court. And the test that the court applies is would validation be in the best interests of the body of creditors as a whole? And that's a hard test. My lord, moving on to what I define as issue 2 in my submissions. And this is grounds 3 and 4 of the appellant's notice of appeal. My lord, I'm going to be fairly brief on these grounds because you may have noted in our skeleton argument we're describing as make-weight points. I'm dealing first of all with ground 3. This is the issue of, I think Mr. Potts has described it as the disputed shares issue. I think that's a good description. And this involves the dispute not between the company and Marine Right, but Marine Right and Docile Right. And if I understand how my learned friend put this, he made the point to the court that the appellant wasn't abandoning this ground of appeal, but it wasn't particularly relevant.
Yeah.
And for that reason, I'll deal with it quite shortly, because for different reasons, the respondent agrees and doesn't think it's that relevant. My lord, to be clear, however, the respondent's position is that the learned judge below applied the correct legal test to this issue and came to a conclusion that cannot be impugned with any error of law. Now, my lords, I know Mr. Mason from Marine Right is going to make submissions on that matter, and for those reasons, I won't duplicate those submissions. But I will make a separate point, just to explain to you why the respondent says this isn't particularly relevant. And this is a point made in paragraph 1 of the respondent's notice. I won't take you there, but it's bundle A tab 4 at 49, which is to say this. If I put it in broad terms, first of all, it wasn't necessary for the petitioner to obtain a winding up to be supported by any other creditor. The established law, and I don't think there's any conflict on this at all, is if there is an undisputed debt, then the petitioner will be entitled ex debito justitiae to a winding up order. And the authority that is often cited in Bermuda and appears in the bundle is Reed Layout, where Mr. Justice Hellman says the discretion only goes one way, which is to the making of an order. So a petitioner does not need the support of another creditor.
So what, just say the name of the authority again?
My lord, it's Reed Layout. I'll give you the.
Just get out Leo.
It's LAEP. It's tab 27 bundle.
Right. Okay. We didn't look at that. I know what you're talking about.
My lord, yes, it's you see it cited in virtually every winding up case.
Yes.
I mean, I do know that went to the Court of Appeal. I assume it didn't affect this particular finding of Justice Hellman.
Well, the ex debito justitiae point is made in numerous. My lord, the ex debito justitiae point is made in numerous authorities.
Right.
And from Mr. Potter's submissions, he quite rightly doesn't oppose that. So if you can prove if you have your petition debt, it's not dispute, or the court rejects an argument by the company that there is a bona fide dispute on substantial grounds, the petitioner will be entitled to a winding up, unless some good reason is shown why a different order should be made. And the court can exercise its discretion in an appropriate case. And I gave the example yesterday. If the company says, look, we've got an asset that can be sold, there's a buyer ready, and within the next 3 or 4 weeks, we can get this money, the court will be well adjourned. So there could be a good reason, but there needs to be some commercial rationale for that reason in order to do so. So, well, that's helpful to have the support of another creditor. It's not necessary. And Sino Charm as the sole creditor would effectively have been in the same position. Now, of course, in view of the judge's findings that Marine Right was a creditor and it's a significantly larger creditor, its debt is $423 million, then it would require wholly exceptional circumstances. Sorry, I apologise. Before an order would be denied. And my lords, that proposition is taken from the judgment of Mr. Justice Newberg, in a case you might be familiar with as well, which is Int'l, which appears at tab 21 of the authorities. Yeah, well, moving on to the next ground 4, I've already made some submissions in relation to this. This is the ground that goes to whether the judge should have considered or put more weight to the question of adjournment of the petition. And my lords, if I can make a reference I made yesterday, which was to say, again, this is not a position taken by the appellant, because its position below, it didn't make any application, even as a fallback position, to suggest to the judge that the petition should be adjourned pending the outcome of the Hong Kong proceeding. That application was made by Fane Drag. And indeed, the application to adjourn for potential restructuring was not an application made by the company. That was also made by Fane Drag, a party that doesn't appear before this court. To make good my reference to the position of the company, I've asked the court to take up bundle F and turn to tab 63 on page 138. My lords, if you look, it's page 138, tab 63. My lords, if you go to the middle punch, and it's line 11, these are Mr. Potter's submissions. He says that if your lordship were anxious about, for example, the post-petition dispositions by learned friends and users, with which we take issue with on the evidence, you could theoretically adjourn the petition to wait and see what happens in terms of the Hong Kong proceeding. That would not be an attractive court strain, and it's not something I would promote. Because, of course, for a company which is listed and trying to raise finance, trying to get its audit financial statements finalized, the fact of pending adjourned petition is helpful to nobody. So, again, this is where the world is turned upside down. You make sense. My lord, I open the spots and invite you to read the next sentence.
Right. Okay.
So, my lord, I don't want to dwell too much on this issue of adjournment. It was addressed, I think, Mr. Potts didn't take it any further than his written submissions. And my lords, there are comprehensive written submissions from the respondent on this point. And I would commend to you paragraphs 150 to 190 of the respondent's statement.
Okay.
My lords, I should touch briefly on the respondent's notice. And in fact, at this stage, we can take up bundle A and go to tab 4. And it's page 50, paragraph 2. Where it says, contrary to the respondent's position, the learned judge was wrong to exercise his discretion to open up the country for the reasons given in the ruling, or for the reasons set out in paragraph 1 here. The petition should be adjourned or stayed pending the determination of the Hong Kong proceedings commenced on the 21st of October 2019 against the respondent for the reasons set out in sub-paragraphs 1b to G, B to G above. Now, pausing there and going back to look at B to G on the opposite page, it said companies in serious financial difficulties and or insolvent there is no prospect of the company paying the petition's debt. The company is a holding company, and its listing on the Hong Kong Stock Exchange has been suspended. There has been a series of unexplained post-petition disposals of assets by the company, apparent undervalue, which require investigation. And there is at least a prima facie case that Marine Bright Limited is the legal beneficial owner of the docile Bright convertible shares, and DBL has no association with current management and shareholders of the company. And then it goes on to say, 2.1, there is at least a good arguable case the petitioner is a substantial creditor of the company. As a consequence of the disposals, it's important that the presentation of the petition is preserved.
Yeah.
So, my Lord, this should be abundantly clear. That is the fallback position of the respondent. So, if the court were to take the view that the winding up order should be set aside, in my submission, there is a strong, if not overwhelming case for an adjournment or stay of the proceedings.
Yeah.
There are two authorities I briefly bring your attention to. In fact, we go to, there's an extract from French in Bundle H, tab 44. And, my lords, if you could turn to page 755. And on the left, there is a number that says 7.546, and it begins in universal non-tariff fire insurance companies. And it says, Peter Forbes and Co. petition for the winding up of the insurance company. And the petition is adjourned for the debt to be established in separate proceedings. Meanwhile, the insurance company went into voluntary liquidation, and the supervision order was granted on the petition of another creditor. Peter Forbes and Co.'s proof of debt was rejected by the liquidator, but accepted on appeal to the court. So that is where the petition is being adjourned whilst the debt is established in separate proceedings. And then we have bi-coastal corporation in Shinhua, the Hong Kong case below, which is the petition of a judgment creditor was adjourned until determination of the appeal against the petitioner's judgment. The company was a non-trading holding company, and the petitioner had been prejudiced by using the date of commencement of winding up established by the presentation of the present petition, because it wanted to question prior transactions. And my lord, the authority of bi-coastal, I won't take you to it because I can exactly summarise there, but it appears also in the bundle towards the beginning of the tab 3.
Yes. Tell me this. The fallback position is that the winding up order should be set aside. The petition should be adjourned until determination of the Hong Kong proceedings. One logical possibility is that the winding up order should be set aside and the petition should be adjourned until the determination in Bermuda of the issue that has arisen in Hong Kong. What do you say about that?
My lord, the court does retain the jurisdiction. In fact, when we come on to the GFM case, the Court of Appeal in Cambridge.
That's why I'm asking the question.
Yes, it can be determined within.
No.
I don't think that was the. I suppose at the moment we're looking at, when I say it's a fallback position, the fallback position alone, and it's also one of the scenarios before the court here.
No.
Of course, there are a number of scenarios. One would be if the order was set aside, that the proceedings are simply adjourned pending the outcome of the Hong Kong proceeding. But of course, a number of other potential scenarios can arise as well, which brings us neatly to the GFM issue. In fact, for the potential scenario the court asked counsel to look at yesterday. And I think it was really this, that if the court is satisfied that Titan is insolvent, but for reasons decides that the appeal should succeed to an extent, and the winding up order is set aside, whether the petitioner could amend its petition to rely upon actual insolvency under section 161 of the Act. Now, yesterday I recall some time ago reading the case of GFN, and GFN.
Forgive me,
Great.
forgive me, you haven't actually answered my question.
Sorry.
I said that one possibility was that the winding up order is set aside and the petition is adjourned pending determination of the relevant issue in Bermuda as opposed to Hong Kong. And the reason for my asking the question is to see whether you have any views whether, if we get to that stage, the determination will be in A, Hong Kong, or B, Bermuda.
And that's the question of disputed debt being determined.
My lord, I hadn't considered that possibility.
I know.
I'm just thinking it through. So, my lord, certainly the court has the power to do that. There are previous examples. For instance, the realloy aircraft case, in the case of which involved some consideration of all that. And there are winding up petitions that do deal with the issue at length. One of them would be Brins, which became a Privy Council case, which I think was effectively a two-week trial of the issue.
So what's the case called?
Brins. I think it's Brins, B-R-I-N-D-S. I think it may be Brins Offshore Oil. Something. So there's a variety. There are winding up petitions which do deal with these very complex issues. My lord, I think stating the position fair, there are difficulties with that.
Yeah.
And I think the difficulties identified by my own friend are those taken up by commentators. The company's court isn't always the best venue in which to do that, because the company's court effectively lacks disclosure provisions, etc. And I think it really depends on the issue. Discovery provisions. For example. Well, no, I mean, the court has the power to make any supervision. What I mean by that is in a risk action, there would be a discovery process, whereas in a winding up proceeding, there would not be a discovery process, unless the court would do something about it.
I mean, I suppose the short answer is, I mean, when one talks about proceedings in Bermuda, the proceedings would have to be as to whether or not the debt is established.
Yes.
And actually involves raising most of the issues, but not all of the issues that arise in Hong Kong. Because the reason why there isn't said to be a debt is because there is said to be the fraudulent conspiracy, which is the basis of the Hong Kong claim. But in the short answer, maybe, that if you're going to adjourn for anybody to decide, the most natural place for that is Hong Kong, since the dispute is entirely subject to the law of Hong Kong.
My lord, that is how the parties
To keep on telling us Hong Kong, we have to understand that
My lord, I don't disagree with anything.
sorry, that's probably a red herring.
My lord, if you look at the case of GFN, it's actually at tab 24.
Yes.
In Bangladesh. I tend to be fairly brief.
Yeah.
In this case, I know my Lord Smedley would be particularly familiar with this judgment.
Yes.
My Lord, when one looks at a petition debt, one is looking at a question of standing.
Yes.
Now, in order to have locus standi, to ask the court for a winding up, a petitioner must have a petition debt. Now, if it is a disputed debt, by that I mean the court is satisfied it is disputed bona fide on substantial grounds. Of course, that doesn't mean that the petitioner has a poor position, because the threshold is low for the company. But in those circumstances, the debt is impugned. Impugned. And my lords, in those circumstances, a petitioner would lack locus standi.
Right.
And it's not sufficient simply that one of the grounds on section 161 of the Bermuda Companies Act is applicable.
Yeah.
So actually insolvency. And my lords, just to deal with that point, if we look at page 477, paragraph 94. And the court in Cayman has done the heavy lifting for us, having summarised a rather large number of cases. The principle is crystallised. A is a person with a regardable case that a debt is due and owing from the company may present a petition to one as a creditor. Now, in Cayman, that's under the statute. It's not under the statute in the UK. But in my submission, the position is effectively the same. You've got to establish your regardable case. The normal rule of practice is that the court will dismiss or stay a petition in circumstances where there is a bona fide and substantial dispute as to the existence of a debt upon which the petition is based. And in an appropriate case, however, the winding up court can refuse to dismiss or stay the petition and can determine the question of disputed debt in the petition itself. So, my lords, this is the possibility of winding up, actually dealing with the underlying dispute. The appropriate cases include those where the court doubts that the debt is actually disputed bona fide on substantial grounds, or where the creditor, if he established his debt, would otherwise lose his remedy altogether, or where other injustice might result. Where the winding up court decides to hear a petition based on disputed debt, it will only make the winding up on the grounds that the company is unable to pay its debts, or that it's just inequitable to wind up, having determined that the petition is on the balance of probabilities a creditor of the company. And it seems to be that is not the exercise that we're dealing with in this case, which is the summary judgment type approach and looking at threshold tests, but actually determining the dispute. It's the company's court dealing with the underlying dispute. But if the court finds on the balance of probabilities that the petitioner is a creditor, then it can go on to update the winding up order. And my lords, if I can ask you to turn to paragraph 102. And if I, that's my suggestion, if you read that paragraph to yourself, because I think it makes this point absolutely clear.
Yes.
So, my lords, the possible scenario of an amendment by the petitioner is, as a matter of law, not possible in these circumstances. And my lords, there is another route, another tool the court has.
Just before we leave that, what Justice Voss was considering, or Petrochemicals was considering this, in that case, was an amendment of the, or say, a petition in order for a determination as to whether or not there was in fact a debt on the balance of probabilities to be made. I mean, presumably, indeed, I think you accept, there could be, in this case, a stay pending the Hong Kong court proceedings, because those proceedings would, in the end, determine, amongst other things, whether or not a debt was due.
My lord, yes. And that is reflected in the Bi-Coastal and Chinle Authority, where there's an adjournment of the petition. I mean, the purpose of the adjournment is to preserve the presentation. My lord, the other tool the court has available in a situation where there is a plainly insolvent And there are appropriate factors that would trigger the jurisdiction to make it. It is the court's jurisdiction to make a winding up order of its own motion. My lord, there is a Bermuda authority on this point called Kinggate. I can pass forward some copies of that together with two related English authorities. My lord, you should have the Kinggate decision. There's a decision called Mansfield and Mansfield, and also a case called Secretary of State for Business versus PLT anti-marketing.
Yes, thank you.
Now, I'm going to start with the Kinggate case. And the Kinggate case was where a winding up order was sought by a company. There was a members' resolution. There were provisional liquidators appointed, but there was no winding up order made. And for reasons which weren't entirely clear to the judge, the petition was adjourned generally. Difficulty then developed that the appointment of the JPLs was serving no purpose, and they wanted to be removed from office. So they sought, by application to the court, for the court to make a winding up order, so they could exit from office and be replaced by the official receiver. Now, their difficulty in doing so was as provisional liquidators, they did not have standing to apply for a winding up order. And the difficulty with the company's position is the company didn't want to proceed for tactical reasons with its petition, but nor was it prepared to withdraw. And the company was insolvent and not trading. In effect, there is a deadline, there is a petition before the court, but it can't be proceeded with. Now, an argument was attempted by counsel for the JPLs that in fact they did have jurisdiction, which was rejected. But if we come to paragraph 15 of the judgment, the court looked at the jurisdiction to make a winding up order except for nations. This is part of the inherent jurisdiction of the court. It said, paragraph 15, Mr. Potts, this is, I believe, Mr. Potts, gave the interesting submission supported by persuasive and strictly indirect authority that this court possessed the jurisdiction to make a winding up order of its own nation. In Lansfield and Lansfield, Mr. Justice Newburgh, as he then was, made a winding up order against the partnership, even though a petition was not before the court. In concluding that the court had jurisdiction to make such a, he made the following observations about the court's power to make a winding up order against the company of its own nation. My lord, there's quite a long quote that goes down to paragraph 17 of the page. I'd ask you to read that quote.
Where do we want us to read down there?
Well, Lord, I'll take up back up from paragraph 17.
Yeah.
And it said these judicial remarks were made in a statutory context, which is, for relevant purposes, identical to our own. The observations were made in a factual context, which was more unusual than those which face this court. I consider the dicta cited by the Kinggate Funds Council both simply persuasive but rather to apply with greater force in the present context. Here there was a winding up petition before the court, on which the petitioner, for tactical reasons, did not want to actively pursue, but did not seek to formally withdraw either. The JPLs applied to restore the petition because they wished to demit office in favour of the official receiver and considered that the winding up order ought properly to be made. Two potentially large creditors agreed that the winding up order should be made, but were concerned that any order made should be made on a proper legal basis, so as not to be vulnerable to any subsequent challenge. It was clearly open to them if any doubts existed about the validity of the company's petitions before the court, to present creditors' petitions on grounds of the company's manifest insolvency. And then paragraph 40, we've got section 161 of the Act. And if one goes down to E, there's a familiar ground of the company is unable to pay its debts. And that's defined, it's not set out here, but section 162 says that either because of deemed insolvency on the statutory demand process, or because the company is unable to pay its debts as they fall due. So that's cash flow or balance sheet insolvency. And it said in 21, I was satisfied with the grounds for winding up the company's petition under section 61A, that's the original members' resolution, or any potential creditor petition under section 161E were made out. I considered that if the company itself was not validly able to apply for a winding up order, the circumstances clearly justified this exercising its discretion to make a winding up order on its own motion, pursuant to either section 161A and or E of the Companies Act 1981. And for the above reasons, I made an order winding up the company on March 2nd, 2012. So there is an inherent jurisdiction. Now this is a jurisdiction not to be applied lightly. It requires exceptional circumstances. And it is a jurisdiction which must be exercised cautiously. So it comes with those caveats and those. The court, in an appropriate case, can exercise a power to wind up a company. And this is
this an appropriate case? Is this an appropriate case?
Sorry, I'm afraid.
Is this an appropriate case?
My lord, yes, it is. I'm going to come to exactly the fact as the court can take into consideration. I'd like to just deal first with the Secretary of State case. I've handed up Barnesfield because it is, of course, just read in the judgment, Mr. Justice Newberg. A number of authorities, number of first instance high court authorities, have followed the Barnesfield approach since that decision in 2002. The most recent was in 2020. And of course, each case will be, when we're looking at exceptional factors, of course, each case will vary depending on its own factors. But a useful case to look at is the Secretary of State case. And this was a public interest petition.
My lord, I'm sorry to interrupt, but I'm just, if I may, for a moment, I'm a little bit anxious that if this appeal is now going to raise effectively a unpleaded ground of cross appeal, inviting this court to wind up a company of its own motion by reference to case law that's been introduced for the first time in response to questions from the bench yesterday. We may not finish today or ever. And I just have to play that marker down because it does seem like we're entering into Kafkaesque territory if the court is invited at the appellate level to wind up this company of the court's own motion. And I just wonder if it's an effective use of time, bearing in mind the constraints that we're all subject to.
Right. Don't agree with that.
Well, this isn't technically the application of the petitioner. We were looking at the scenarios available before the court. And one of the scenarios that would actually follow is the exercise of the court's inherent jurisdiction.
Right.
So I don't agree this is unpleaded.
Keep going for the moment.
My lord, yes. So this is a public interest petition. PLT Anti-Marketing Limited was a cold calling company. There were issues with its business practices. My lord, for various reasons, the proceedings became strung out and a winding up order wasn't made. And it actually got to the point where the company had ceased doing business during the currency of the proceedings. And the company itself applied to the court to make a winding up order on the grounds that it was unable to pay its debts, and also the alternative, it was just and equitable for it to be wound up. And I'm looking at the bottom of the first page, so this is by I. The company's evidence was that it had been unable to make new sales since shortly after the presentation of the petition at the end of 2013, and its income had gradually declined in the 30 months that the petition had been outstanding. The lack of new sales and the cost of litigation had led to a decision to cease trading and had rendered the company insolvent. The company argued it would be in the best interest of the company and its creditors for a winding up order to be made on the Secretary of State's petition, which could, if necessary, be amended. The court had jurisdiction in exceptional circumstances to make a winding up order in the absence of a petition, and the case for winding up on the grounds of insolvency was indisputable. Whereas the case for winding up on public interest grounds was merely arguable. It would not be in the public interest for there to be any further delay or expenditure. The Secretary of State argued there was no jurisdiction to make a winding up order in the circumstances or to require him to amend the petition, and the circumstances were not exception. In the held section, the first part, the court had jurisdiction to make a winding up order, following Lansfield and Lansfield, also Harlow and Creative Staging Limited was applied. My lord, rather than perhaps me read the second part, if I ask you to read down to the bottom of the page.
Yeah. Yes, I've read that. Why did the Secretary of State object to the court taking the course that it did?
My reading of it was in terms of the Secretary of State didn't consider there was jurisdiction. And the court went on to
Despite
conclude.
the finding in Lansfield that there was.
My lord, some light is shed if we go to the body of judgment 46.
46, right.
And it said that, paragraph 46, assuming, however, I'm wrong in that, but it seems to me that this is as a thoroughly exceptional case, as in Lansfield itself. This is a case where there's been a winding up petition for some 2.5 years. During that time, the company has become insolvent. Its business has come to an end. The sole director can see no prospect of ever resuming trading. The life of the company is clearly at an end. Some 2.5 years ago, the Secretary of State took the view that the direction of the company should be taken out of the hands of its then directors and assigned to a responsible, independent third party in the person of the official receiver as provisional liquidator. The court refused the application to appoint a provisional liquidator, but it did so only on the undertakings from the company's directors as to the future manner of trading. Now the company is no longer trading. It seems to me that it is imperative that an independent third party is appointed to assume responsibility for the company's affairs. As Newberg J. said, there will be circumstances in which petition will not be necessary because the circumstances are so plain and the inevitability, appropriateness, and urgency of the winding up petition so clear that it would be a denial of justice and a waste of time and money for the court to refuse to make an order here. Sorry, there and then. In my judgment, this is precisely such a case. I acknowledge that the Secretary of State will not be able to establish the public interest grounds on which he presented his petition. But at the end of 48, it says the public will know, as a result of this judgment, that the Secretary of State takes his responsibilities in enforcing the public interest extremely seriously. So there was a petition in this case. The court determined it could make an order on that petition on the just and equitable ground. The position, of course, being slightly different for the Secretary of State, because he's not a creditor. He's there pursuing public interest grounds. So there was no need for exceptional circumstances. But the judge did conclude there would be exceptional circumstances in the facts of that case. So why should the court consider exercising its jurisdiction in this case? My Lord, there are a number of key points which in my submission move powerfully towards that conclusion. They are cumulative and should be viewed together. Firstly and fundamentally, this is plainly an insolvent company. We've seen that from a wide range of evidence, but of course most pertinently the first report from the Joint Provisional Liquidators. It was insolvent in 2019, the petition has deteriorated, and it's insolvent in 2021. By its own announcements, has no working capital. But that, of course, is not enough. But the company has also had its trading suspended on the Hong Kong Stock Exchange since April 2021. That's nothing to do with this petition. It's because it hasn't filed audited accounts. In fact, has filed no proper accounts since, I think, 2018. So it's not trading on the Hong Kong Stock Exchange, nor is it an active business. It's a holding company. The business of Titan Group.
Has it lost its listing?
My Lord, no. Under the Hong Kong Stock Exchange rules, unless it can produce audited accounts, and my understanding is that it would be delisted by October of this year. But it's been
of this year.
Its listing has been suspended.
Yes, it has. It's since April 2021. So it's not trading on the Hong Kong Stock Exchange, nor is it an operating company. Its business is conducted through operating subsidiaries. Subsidiaries like Titan Fujian, before it was disposed of, subsidiaries like Opco, that owns, I think has an interest in the shipyard. And my lords, we've seen in the commodity trading, it's not the company trading, it's the company's subsidiaries, like PetroTitan or Brilliance Glory, that have done that trading. So it's a holding company. And it's a holding company without any money. It has no working capital. It's made that announcement on the Hong Kong Stock Exchange. And my lords, I took you yesterday to the cost judgment, where it was undisputed by the company that it's been funded solely during these proceedings by Mr. Zhang and loans that he has made through his corporate vehicle. And I should add that if a winding up order is made, it doesn't stop the operating subsidiaries from doing what they do. It doesn't have that direct effect. This is a case, as in Kinggate, where the petitioner, in this scenario, can't proceed for a different reason, but the effect is the same. As in Kinggate, there is at least one other significant creditor, which is supporting the winding up. That's Marine Bride, with a debt of 423 million. We understand there are other small creditors, but I don't know their position for the purposes of today, or to make any submission in respect of their various positions. We have had, exceptionally for a winding up petition, 2.5 years of proceedings, as in the PLT case, where the financial position of the company has demonstrably deteriorated. And where there has been a wholesale disposal of assets for apparently nominal value. And in these circumstances, it would be inappropriate to place an insolvent company back into the hands of the directors. And there is only one executive director of this company, and that is Mr. Zhang, who was described as the prime mover in the cost ruling. He is the driving force. My lords, you've seen what the company has done. It has increased its indebtedness during the period of these proceedings. Money has been loaned from Mr. Zhang. You've seen evidence, it's undisputed, that money was raised in March 2020, $8 million through convertible bonds on the Hong Kong Stock Exchange. And that is just to fund this litigation and to keep the lights on at Titan and pay salaries. It's a desperate situation. So we have further indebtedness. And of course, we have the creation of new creditors, because the convertible bondholders will be new creditors when their debts come to be paid. And my lords, this is, in my submission, exactly the type of case where the affairs of the company do require robust investigation by an independent third party, appointed by and reporting to the court. And that is particularly apparent in relation to these asset stripping style disposals that have been made. My lords, lastly, there is a public interest element here, because this is a publicly listed company. Albeit its listing is suspended, there is a public interest in how this company is dealt with. So we have an insolvent company, we have these powerful factors that, in my submission, go towards the exercise of the court's jurisdiction. And underlying this, there is the trite principle of law, that when a company is insolvent, the interest that must be considered is the best interest of creditors. My lords, there can be no benefit to the general body of creditors in deferring a winding up order. If the winding up order is set aside, it is seemingly only for the purpose, from the company's point of view, of either disposing of more assets or continuing the Hong Kong proceedings. My lords, I should take one final point, and I think this will be raised against the court's exercise of this jurisdiction. As I say, it's an exceptional jurisdiction to be exercised cautiously. And in the cases that have come before the courts, the cases do not involve significant opposition. Now, the opposition, of course, in this case, would come from the directors of the company, in theory from Famed Dragon, and I suppose perhaps in theory from Docile Pride. But my lords, in terms of any such opposition, that must be seen in its context, because of course, Famed Dragon is a shareholder on any view of the finances, and particularly the first report of the JPLs. There is not going to be a surplus for distribution in this case. There is no tangible interest held by any shareholder of Titan.
Sorry, your voice drops. I didn't hear the last two sentences.
I do apologise, there won't be a tangible interest for Famed Dragon in any surplus. So it's out of the money. It has no real interest in these proceedings. Docile Bright is not a registered shareholder. The registration lies with Marine Bright, as does the share certificate and board approval.
Yeah.
And if there's any issue between Docile Bright and Marine Bright, it seems it would have to be dealt with elsewhere. And my learned friend, Mr. Potts, has alluded to some proceedings somewhere else. And in terms of the company, well, again, in the case of insolvency with no working capital and this depth of insolvency, where it can't even be said, if the Hong Kong proceedings rumbled on 2 to 3 years down the line, there is, for the purposes of this argument, success for the company. Any money recovered in damages barely touches the sides in terms of its indebtedness. So, my lord, there is no real possible basis for objection in this case. And objections really can only be seriously entertained from those who have a viable stake in the company. And my lords, I've covered quite a large amount in a short time. I'm also conscious my learned friends have the opportunity to respond. My lords, those are my submissions, unless I can assist on any further.
Well, thank you very much. There are two matters. One arises out of what you've just been saying, and the other doesn't. The one that arises out of what you've just been saying is this. You said it's necessary for the company to be wound up in order that a robust approach can be taken to various matters, including presumably the existence of a debt in favour of the petitioner. How would that work in practice?
My lord, perhaps we could, I think, to answer this question, we go back to GFA,
Yes.
which is a tab 24.
Yeah. Mm-hmm.
Paragraph 90, we start at 91. There's a reference in 91 to the Privy Council decision in Palmer. And if we go on to 92, it said Lord Hoffman's statement that in the course of that process, the rights of creditors may have to be determined. But such a determination is not necessary at the stage when the order is made. We're simply pointing out that final determinations are made in the course of the liquidation process itself. And at that stage, in that case, the assignee's interest can be taken into account. It is well known that liquidators can reject proof of even an undisputed petitioning creditor's debt. And this makes the point we touched upon yesterday, which is when a petitioner appears in front of the court, it has provisional standing.
Yeah.
Because the court, by granting a winding up order, isn't saying we accept the petitioner's debt, just that the petitioner has shown, in effect, a good arguable case. Or the other way to look at it, the company hasn't raised a bona fide substantial dispute. The final determination is made on the proof of debt process, and that is a process within the control of the liquidators. And the liquidators have various powers in that respect. They don't have to just simply approve or reject the debt. They can ask for further information. They can put
Or they could decide that they wanted to wait the outcome of the Hong Kong fleet.
My lord, yes, that would also be a possibility. As I say, as independent professionals appointed by the court, they would have to take their own view on those Hong Kong proceedings. Of course, the petitioner hopes they'll take a particular view, but it's up to them and their professional expertise to do so. My lords, there is, as my learned friend mentioned, there is a process of review available, also in terms of the proof of debt procedure. But that doesn't mean, and it's difficult to see, I think perhaps my learned friend was supposing there might be some challenge if Sino-Charm's debt was accepted by the liquidators. It's hard to see where that could viably come from, but it doesn't reopen the same issues, because the issue there would be a review of the liquidators' exercise of their discretion. And for instance,
Well, the person who might object is Mr. Zhang.
Mr. Zhang could object. He's actually, during the currency of these proceedings, he's become a creditor of the company through his own.
But does someone in Mr. Zhang's position have a standing to interfere with the proof of debt process for the liquidator as between liquidator and creditor?
My understanding, my lords, is it's the same as my learned friends, that a creditor can raise an objection. I don't think this is an area that's subject to particular reported case law.
Where is the process of review laid down? Is it statutory or in practice?
My lord, I think it's in the company's winding up rules.
Yes.
I would have to check that. I think
Okay.
it's a fairly short section.
Yeah, okay. We can look that up.
George can help us.
Right. Right.
My lord, the only point I was going to add, if one is looking at a review of a liquidator's decision to admit proof of debt, it's not that we're opening up all the same issues as before this court. We'd be looking at the exercise of that discretion, or of that power, I should say, by the liquidator.
Yeah.
And what is really required, what should have been done by the company, is before putting forward these arguments of fraudulent conspiracy, they should have gone and obtained an independent. My lord, they should have obtained an independent report in relation to these commodity transactions. Now, it's perfectly possible for the liquidators to carry out the process either by themselves or more likely by instructing an independent professional to review the issue of commodities contracts and therefore take a view on the basis of that independent report. And my lord, so the issues on any review of acceptance of proof of debt are not the same as all the multifarious issues that have been raised by the company in these proceedings. We'll be actually looking at the exercise of that power by the liquidators.
Yeah. The second matter that I just wanted to invite your assistance on, there's a body of evidence that Mr. Wei Bing and Mr. Tang purported to use their supposed power in relation to the debt owed to Sino for their own purposes or to obtain a ransom. What is the significance or non-significance of any of that?
I think it's the judge found in the ruling that this idea of entrenchment of control through the convertible bond is inconsistent with the collective winding up process of the petition. The debt isn't paid, winding up process is commenced. That's just a normal commercial and legal process. It's not consistent with entrenchment of control. My lord, I made a submission yesterday which touched upon this point, is that the convertible bond is only effective as a tool. Firstly, if you can establish that Sino is controlled by Tang and Wei Bing, but also it depends entirely on there being a default under the convertible bond. And in 2016, Titan had come out of the court restructuring process, and it was looking at expansion. It wasn't particularly cash rich, still had liabilities, but it was pursuing a policy of expansion, further investment and growing the business, which again is inconsistent with, I mean, it'd be quite incredible to say, all this is being brought about in order to create this leverage. And then Tang and Wei Bing have somehow conspired to ensure that the company fails, that it doesn't have the money to repay the bond. So again, it's incredible. And my lords, bearing in mind that Tang was an executive director of the company right through until October 2018. I think Wei Bing was on the board as executive director, I think, until the end of the first quarter of 2018. None of that makes any sense whatsoever. So the argument of entrenchment is simply perverse. It's a device created by the company in order to justify the position.
Right.
They don't have money to pay this debt. They have to come up, they have to dredge around for a defense.
Right. Thank you very much.
So one question before is the
Yes.
exercise of the exceptional jurisdiction to wind up of the courts on motion that you would invite us to invoke. The first premise, as I understand, is that the company is hopelessly insolvent. Is there any dispute about that?
My lord, I wouldn't go as far as say, every case I've looked at where there's jurisdiction been exercised, the company has been insolvent. Not to say, be cautious here, not to say the principle can perhaps be applied in other circumstances. I think what was being said in Kinggate, Lansfield, and also the other case we looked at, was one of the statutory grounds has to be available. And in fact, in Kinggate, there were two potential grounds, because the petition had originally proceeded by a member's resolution, which is under section 161A of the Act. And so there are all the various, there's parts B, C, etc. of the Act, which may be applicable. But in reality, the one that's almost always used.
But in this case, on the facts here, that would have been your starting premise, that you would advise us to proceed on.
My lords, the company may kick and scream and say that it's not insolvent, but that is against a mountain of evidence.
I understand that, but I take it you'd proceed on the basis that we have to be completely satisfied about that as a starting premise.
And my lords, you can be satisfied because you have the announcements of the company, particularly in Mr. Zhu's seventh affirmation. And I would stress, this is not just evidence, this isn't evidence from the petitioner. This is the petitioner saying, these are the announcements made by the company. The company said it was balance sheet insolvent. The company said it didn't have sufficient working capital for 12 months. It needed to raise capital. No plans, no concrete proposals as to how to do so. If you want an independent view, you have the JPL's report. But there is effectively file after file of evidence. Now, the company has always avoided any admission that it's insolvent. This is why, to a certain extent, the petitioner has been rather sceptical about Mr. Lai. Why isn't Mr. Lai actually setting out the position? Why isn't Mr. Lai revealing that the company is only supported by Mr. Zhang's loans?
Yes, thank you.
Thank you very much. Yes. Me.
My lord, do you need to proceed straight into?
We are, if you are.
My lord, yes. So my lord, before going into the substantive submissions of the right, I just wanted to pick up on the company's submissions previously. The ground 3 of the appeal is fairly irrelevant to the argument that those sub-rights and the right shares. Well, my lords, respectively, it is highly relevant to these proceedings for more than 1 reason, which I'll take you through. So the first reason is that if the court does find the debt is disputed on substantial grounds, then the winding up rules at Rule 27 provides that any other petitioner can be substituted for the petitioning creditor. Would you like a copy of Rule 27?
Not particularly.
So, my lord, then on the other hand, if the court finds that the debt is not disputed on substantial grounds, then of course the court has to take a decision as to the future of the company. Although ex debito justitiae provides ordinarily the court would wind up the company, as the court has touched on previously in these proceedings, there is a consideration as to possible restructuring. Use of creditors would be considered at that stage. And if whoever is the holder of the share would be the majority, is the majority creditor of the company. So the dispute is between docile right and marine right is very relevant and is important in these proceedings. This was considered by the Chief Justice in the judgment below, where he considered that marine right was the majority creditor, and that the views of the majority creditor were that they wished the company to be wound up.
Yes.
And of course, those upright position in the proceedings are that they wish for there to be a restructuring and want to avoid winding up on any grounds whatsoever. But of course, that's to be expected because they have a common holding company, of course, GZ being. The only other point to make on this issue is if ground 3 wasn't relevant, then why am I marine right here? And if it's not relevant for the marine right to be here, the marine right should be compensated for being here for no reason. But the marine right stand by that it is relevant for them to be here for the reasons it's mentioned.
Yes, and I'm not quite sure. I mean, are you saying that if we were to come to the conclusion that the dispute, the debt was disputed on bona fide and on substantial grounds, that you should be substituted as the petitioning creditor?
My lord, what I'm saying is that there is that Rule 27 provides that there is a possibility that the marine right may wish to be substituted as the petitioning creditor.
The answer to my
Doesn't answer my question, and there are all sorts of possibilities. But the possibilities are not of any interest unless anyone wishes to avail themselves of the possibility.
It's still a relevant consideration. It's not a done deal.
But are you saying that that's a step you should take in the event that the Sino charm debt is not found to afford losses? If Sino charm do not have that locus to pursue the petition, are you suggesting to us that we should substitute marine right by virtue of your position as creditor?
Well, my lord, there has been that application for you, and marine right's primary contention is that it's very clearly the largest creditor, and the company should be wound up. The evidence that Mr. Lai, who's heavily conflicted in places.
But the question of how we get there is really what we're looking at.
If Marine Right is not making an application, it's not making an application. Accordingly, the possibility that it might make an application is relevant. Present purpose. The fact that it supports the petition as a major creditor is, but the fact that it might apply to be substituted isn't, it is not in fact applying to be substituted. Okay.
My lord, I'll deal with
So I think you're prepared to comment on that. You're not going to have another opportunity to speak to this.
My lord, I was just going back on that point, that Marine Right feel that it is relevant because they wouldn't be able to take a view on whether they would want to be substituted as creditor until an order is made that effectively there is a bona fide dispute on substantial grounds.
I'm sorry, I didn't hear that.
Can you speak up a bit? It's quite difficult to hear you.
We have lots of perspex between us and you.
Yes, deflects your voice.
My lord, well, with regards to Rule 27, Marine Right wouldn't know whether they wish to amend until that junction has been reached.
But the danger with keeping one's powder dry in that fashion is that the opportunity will have passed.
Well, respectfully, my lord, I don't think it would because the wording of 27 actually takes effect after the court has made the determination that the petition.
Forgive me saying this is terribly unhelpful. I quite understand that the problem doesn't arise unless we decide that there is a reasonable defence to the debt. But it would be perfectly possible for Marine Right to say If you were to decide that there was a reasonable defence to the debt, then we would wish to be substituted as the petitioning creditor to say we're not going to address our mind as to whether we should be the petitioning creditor until you say has the result that we produce. I'm afraid our judgment is not going to be written extempore, and it may take some time before it is delivered. If we deliver our final judgment in a month's time or something like that, for you then to pop up and say, if relevant, oh, well, I'd like to be substituted as the petitioning creditor, is very wasteful time.
My lord, unfortunately, I don't have instruction.
No, right, okay.
It was really to make the point that there is,
Okay.
lordship's already know, there is that
Yes.
facility to go through there.
Yes, well, I give notice that if you were to make an application in 6 weeks' time, the likelihood of being favorably considered may be reduced, but the fact that you haven't mentioned it before.
My lords, I understand the instructions are that the rebar would want to be substituted if the court found that there were not if the dispute was made bona fide.
So having told me a moment ago you hadn't got instructions, you've just got them.
Yes.
Right. From your learned junior. From your learned junior.
Well, from my senior.
Your senior.
The senior solicitor, attorney and barrister.
I'm sorry. Okay. Right. Right. Right.
So my lords, dealing with the substantive submissions, as I've outlined, Marine Bright's position is that it's very clearly the largest creditor of the company on a prima facie basis. And Marine Bright supports the petition and the winding up of the company.
Just a second. Of course, if you were to be substituted as the creditor, it would be necessary to establish that there was no bona fide and reasonable defence that you were not the creditor.
My lord, yes, we would have to amend. We would have to amend, put in a further petition, and.
Well, not simply that. That's a question of mechanics. But we would have to be satisfied that there was no reasonable defence that in fact it was docile right.
The court would have to be satisfied that Marine Bright were the.
Yeah. Yes. Okay. Right.
And there is a dispute as to Marine Bright's entitlement to the proceeds of the redemption.
My lord, yes. We didn't realise until the start of these proceedings that Mr. Potts was representing both the company and Docile Bright. We presumed that Docile Bright had.
This is what he's saying. He does not.
Well, I represent the displaced board of directors on behalf of the company.
But Docile Bright is represented by Kerry Anderson.
Yes, they're just not attending this appeal as an interested party.
So,
Are there some proceedings going on elsewhere between Marine Bright and Docile Bright?
2 weeks ago, my lord, received a notice was issued in the British Virgin Islands seeking to set aside the transfer from Docile Bright to Marine Bright on the basis of the transaction at an undervalue. So in those proceedings, it appears that Docile Bright are saying that they are worthy owners of the preferred shares and that the transfer was an undervalue. In these proceedings, Mr. Lai appeared on behalf of those upright seems to suggest that perhaps those upright didn't vote for shares and perhaps that's.
So taken by which party? Those are right.
Those upright would say, Mr. Lai has produced evidence in these proceedings.
No, I'm interested in the parties to the proceedings.
Oh, it's, yes, those upright, through its liquidator, the British Virgin Islands, against, marine rights.
Right. Okay.
But again, those proceedings were issued at the last hour, which is very similar to the Hong Kong proceedings being issued at the last hour in the petition. So there is some similarities. And the transfer was 5 years ago now. And it's quite remarkable that it's only 2 weeks ago at the same time submissions were exchanged where the questions there's been no applications before the BVI court to say it's not suddenly an application comes. It's quite unsatisfactory. My lords, I've split my submissions up into three areas. The first is the correct legal test at the winding up hearing as to determine supporting creditors' claims. Issue number 2 is the evidence in support of marine rights title to preferred shares. And issue 3 is the judge's reasoning judgment at first instance. So, dealing with issue 1, the first issue that arises on the party's skeleton submissions in respect to the docile right to marine rights contentions is the correct legal test to apply when considering creditors' claims other than a petition creditor. The company contends that the court should have also decided the issues to legal and or beneficial title to the redemption funds of preferred shares, upon which marine rights claim is based. Respectfully, this is not correct. Marine rights address this in paragraphs 8 to 10 of its reply submission. That's it. The G 5138, which might be worth a quick look.
Section 164.
So it's a G5, folder G, tab 5, page 138.
Have them in loosely.
So,
Well, just a minute, I'm getting confused about this. You say that the judgment was right to conclude that Marine Bright is prima facie a creditor of the company for the purposes of the winding up proceedings. I mean, if Marine Bright was the petitioning creditor, it would be necessary to establish that there was no bona fide and reasonable defence to the proposition that it was a creditor.
if that's raised, right? If that's
If
raised.
that's raised.
That's raised.
But as we know, Marine Bright is not currently a petitioning creditor. So why are we concerned with a prima facie case?
This is the test that the Chief Justice has obtained from the opus. We raised that in the judgment.
Yes, can we do that?
Yeah. A1,
Yeah,
page 30. Page 30.
yes, thank you.
Paragraph 79. Reopus is in the bundle.
But we'll have to look at reopus, but there are two different questions. One is what has to be shown in order for the petitioning creditor to be able to obtain the relief sought in the petition. And secondly, what has to be shown in order to take into effect the support of another creditor.
That's right, my lord, yes, and that's what was discussed in reopus, that there's two distinct tests.
Well, that's what I thought.
Yes, that will reopus agrees with that. And the underlying thoughts are actually obtained from a British Virgin Islands case, and that's quoted in reopus as well. And my lord, this is supported by French as well, which is referenced in the rewrote skeleton.
Where's that?
So that is at the tab 5. There should be pages at the end.
Attached to the skeleton.
Right at the end of
No, not attached to this one.
G142.
No, I stopped at G141. Not at G142?
I have it on the back of my books. You have extra copies of the extract from French?
Do you have
I
a different
understand
copy?
it's in H46 as well.
Let's have a look. Yes, we've got that.
So yes, H767 states the section about the views of
Yes.
creditors. And of course, the court doesn't have to take into account the views of creditors, but in most cases, the court does. It is a matter for the judge at the hearing. So there is a wide discretion on the court in assessing the views of creditors and strength of their claims.
This all begs the question whether we're talking about a creditor in the first place.
Pardon, my lord?
This begs the question whether we're talking about a creditor in the first place.
Absolutely. We get back to the simple question again as to marine rights standing as a creditor and the evidence in support, the weight of the evidence in support, which we say is overwhelming.
Yes, well, all we've got at H46 says that the court's entitled but not bound to take into account the views of the creditor.
Yes.
But that begs the question, as the Lord has said, how much you have to show in order to qualify as a creditor for these purposes.
Yes.
To which you say, Opus says, that for these purposes, that is, say whether or not the court should take into account the views of a putative creditor, all that's necessary to show is that he or she is prima facie a creditor.
Absolutely.
Yeah, I follow. Thank you. Right, that's point number one.
Yes. The second point dealing with the evidence in support of legal title. I would say the evidence is really, really overwhelming. But before going through the points in support, it is worth highlighting to the court that the docile right has issued those proceedings in the Virgin Islands, which is the view of to the evidence of Mr. Lai as to everything in these proceedings, not just the ownership of the shares, but his whole evidence cannot really be considered reliable by the court. If on the one hand he's suggesting that docile right was the owner of the preferred shares, on the other hand, as sole liquidator of docile right issued proceedings in the British Virgin Islands, to the effect that docile right were the owner of the shares. So this is something that I'd ask your lordships to consider at the very outset and throughout, not just ground three, but also when dealing with his evidence and support that there is this big fraudulent scheme. Mr. Lai has given evidence in these proceedings on behalf of the company and on behalf of docile right in a joint capacity. He's the non-executive director of the company and also the sole liquidator of docile right. Docile right cannot, on the one hand, in the British Virgin Islands, accept the transfer, and on the other hand, in these proceedings, contend that the transfer was not effective. One should also consider that Mr. Lai's evidence in these proceedings has never been certain. He's merely just speculated in lots of places. So we can see that at bundle C 38, which is Mr. Lai's third affirmation, paragraph 17.
Paragraph 17.
17A. The available information may support a view that docile right may have acquired ownership.
So where are we reading from?
17A.
17A, right.
Not the strongest of terms.
Absolutely, my lord, yes. Now dealing with the evidence, the evidence in support of the new rights title, so preferred shares.
So you said a moment ago that Mr. Lai had given evidence on behalf of docile right and on behalf of the company.
Yeah.
And he's given evidence in his capacity as the liquidator of Flame Grant.
And Flame Dragon as well, my lord. So he's wearing three different hats. I'm going to few further submissions about that in due course, but how its position could not be conflicted is simply.
So it's Morris, that's Fame Dragon, docile bright, and what's his position with the company?
Non-executive
Oh,
director.
non-executive, that's right. Yes, I follow. Get confused as which chap we're talking about.
Yes, my lord, and how this delay can be likely impartial.
Yes.
And when, as Mr. White said, that Flame Dragon is interested in going to clearly to continue the proceedings on the basis that it's insolvent itself,
Hmm.
and how he can then act on behalf of those self-right and alleged creditor, which is seeking. It's just untenable. Position is untenable.
Yes.
So my lords, moving on to the concrete evidence that shows Marine Rights was the owner of the shares. Firstly, there's the register of members of the company, and that's at D3.
Yes. It's page 2763.
That's the one, yeah. Of course, we know that section 68 of the Companies Act provides that the register of members shall be trying to place the evidence of any matter in the register pursuant to the Act.
Yes.
We can see that those are rights here in the register before Marine Right, which shows good and correct chain of title as Marine Right contends. Only the company can update a register of members, and so this evidence is pretty concrete as to Marine Right's good title to the shares, showing itself listed as a register as a member, and the those right party who it can produce a sold note and a share transfer document from is listed above it. We also have section so no proceedings have ever been instigated to rectify the register of members throughout all of these proceedings, which could have been done quite easily by either the company itself or by by docile rights or Saturn. There's just been complete neglect and disregard. If people that were running this company which taking things seriously, this would have been something that could have been corrected quite quickly before open court proceedings. We know of no proceedings to date or other legal challenges. Number two, Marine Right was issued a share certificate, which is just over page 2764. We know by section 52 of the Companies Act that the share certificate shall be filed with the evidence of title. Again, the company has not ever sought to report the certificate or make corrections to Marine Right status as the owner of the preferred shares from the transfer date.
Do we know who the signatories of this share certificate is?
We don't, my lord. There's been no challenge as to the authenticity of that signature or otherwise. That was actually my next point.
Yes.
So back to C38 again. So my third point is that there was a board resolution approving the transfer of docile right to marine right. That's contained at C38, page 387, paragraph 14.
What paragraph?
14.
We got the actual resolution somewhere.
No, conveniently, the company cannot locate that particular resolution. But they have been able to produce documents that we understand were considered by the board at that time, including the share transfer, the sold notes, and the confirmation that Marine Right was affiliated with G2. Which I plan on taking too shortly.
Yes.
So it's paragraph 14. It's the line confirms that there was a resolution, and he confirms his understanding that this took place on the 20th of September. No steps have been taken to unwind or dispute this process, and no evidence has been produced to suggest that the board resolution should not have been made, or that it was made ultra vires or otherwise.
Right.
Which ends these completely false. If we go to D2 tab 49, we can see those documents that have actually been produced by the company. Understands.
D2 tab 49.
That's right, yeah, it's page 2343.
What's the share transfer?
That's the reference to share transfer. And
Yes.
the transfer shares signed by both parties, signatures not taken issue with.
Sorry, what page is this?
2343.
343. Thank you.
The consideration is stated in the transfer of shares, 20 million. The sold notes on the next page 2344 actually states consideration received USD 20 million US dollars, and then that's signed by docile right.
Yeah.
And then on the board note, consideration paid, we have got a sign by the absolutely no contest as to whose signature these are, or whether these documents are genuine or not.
Yes.
It's crystal clear that the Marine Right are the owner of the shares. But not only that, because the evidence is so weak as to the docile right contentions as to the shares, the court, in my submission, can take an inference that there is some level of play. Why would docile right put forward such a weak and unreasonable claim in the first place? And that's to support the remaining board of Titan to seek to object to the winding up petition and seek to carry on the company on the basis that it's a majority creditor and its view should be taken above everyone else, which is what its position was in the first instance here.
Yes.
The company's contentions against the right, so in paragraph 101, it's skeleton, which is at environment G1.
So which paragraph did you say?
101.
Thank you.
Page. So as I've already addressed, that the should have the ability to decide the issue in these proceedings. Winding up proceedings on the appropriate form to decide an issue, especially with the involvement of numerous other parties that would be vexed by the court carrying on and deciding an issue. Paragraph 102 of the company's skeleton then provides 7 points, which it says shows that the judgment of first instance was wrong. Now, these have been dealt with extensively in the Marine Rights Reply skeleton, which is tab 5. We're dealing with each in turn very briefly now while looking at the claimants, the company's skeleton arguments. Point A is that the transfer could never have taken place because Marine Rights was not an affiliate of GZE. We've just seen that D2 over the page from the sold note was a letter from the company, so the letter from two Titan confirmed that it was an affiliate of GZE. Did your lordship see that?
No.
Sorry, I might need to go back. Sorry, it's D249, 2343, 2343. Five is the letter to Titan Petrochemicals. I'm a read by confirming they were affiliates of GZE. As I said, these documents were produced by the companies. Presumably, they work for the company when it approved the board resolution of the transfer. And my submission of court should really look behind that, or the court should need to look behind that for the proceedings.
Wait a minute. What is said in the argument at the top of in A on G33 is that the disputed shares could only be transferred to GSE or its affiliates. Marine Bright is not GSE, obviously, and it is not disputed that Marine Bright is also not an affiliate of GZE.
Well, that's just not true.
It is.
Oh, sorry, I thought you were talking about the submissions.
Well, no, I'm puzzled by the assertion that it's not an affiliate of GZE. With a letter that says we are an affiliate of GZE.
The affiliates.
I don't know whether, my lords, if you have read the transcripts in the first instant proceedings.
I have certainly not.
Then it's actually, I can take you to it very briefly, where it's on the left, and it's explained by George that perhaps it might be good for us to go there.
Yes.
What tab?
There's tab 62.
Yep.
Ms. George's submission starts on page 217.
217.
217. The bottom of 218, it's line 23. George submits that the rewrite were not involved in the original transfer. They didn't over rewrite at the time of that transaction. They were not personally involved.
So where are you, 217?
218.
218. You said 217.
Sorry, that was the start of the.
So 218 where?
218.
23.
Right. Okay.
Our transfer not involved.
Yeah.
Yes, yeah, that relates to GZE.
No.
Well, it's confirming. It's confirming there that the at the time of the transfer, Marine Bright, the current owners of Marine Bright was were not picture essentially.
Well, that doesn't tell us anything about whether GZE and Marine Bright were or were not an affiliate. The fact that the current owners don't know doesn't tell us the position.
There's simply been no evidence before the court as to whether Marine Bright were an affiliate at the time of the transfer or were not an affiliate at the time of the transfer. There's just absolutely no evidence before the court. The only evidence before the court is something produced by the company, the letter saying by Marine Bright confirming that it is an affiliate of GZE, and an order resolution by the company to that effect
So they acted on it to
that they
effect the transfer.
yeah, there's been no other evidence to contradict that at all. It's for the Marine Bright hasn't got to prove beyond reasonable doubt that it's that it is the rightful owner, and it's with the registered share certificate and the register of members. It's up for if the company wants to challenge that further, they must bring evidence.
But the transcript doesn't help us one way or the other.
I think there is. I think there was some mention as to that at the time of the ownership, that there was a they were an affiliate. Marine Bright were an affiliate. But I wasn't expecting to go into that today, but it is in there. I mean, this
Well, it is in there, and I mean, I don't understand this, I don't quite understand it, so you weren't expecting to go into that today. Give us the reference data, but if there is something in the transcript which does address the question whether GZE and Marine Bright were affiliates at the time of the share disposition, I would like it.
So we will try and find out.
Yeah.
Dealing with the which is Titan's 2017 annual report. The revised submission here is that the register of members and the shares title. No evidence to suggest these documents are fraudulent or otherwise, and just because the document produced by the company fails to mention the transfer does not take away from the actual true ownership of the shares. This is very good point. And
Are you reading from somewhere or
Referring to.
are you reading from somewhere? What you just been saying?
I was looking at paragraph B of the
Yes.
paragraph B of the of the
Pillar and skeleton.
yeah. So
Right.
in this paragraph, the company pretend that an annual report of the company in 2017, which admitted that Marine Bright were the owner of the shares. It actually stated that Docile Bright was the owner of the shares then. Marine Bright, the company title trying to suggest that this supports that there was never any transfer to Marine Bright, which Marine Bright say this is an annual report. It doesn't take place in the registered funds. So dealing with point C, my lords, this is again a similar point made by the company that Marine Bright never filed a disclosure of interest form of the Hong Kong Stock Exchange, disclosing its alleged interest in the shares. Now, again, there's no evidence that Marine Bright had to file a disclosure with the Hong Kong Exchange. And in any case, a failure of a regulatory or compliance step in any way affects true ownership or title to the shares, and that's another red herring. Dealing with point D, the companies say that the company here seems to suggest that Docile Bright never had title to the shares in the first place, and therefore never the transfer to Marine Bright would have just not been effective. Firstly, that's at odds with the British Virgin Islands procedures. And secondly, actually, it can be explained quite simply. Looking at D3, tab 58. D3, tab 58, it's page 3601. So, my lord, this is you'll see from the writings, you'll see from the evidence of Mr. Lai, he states that C38 in his affirmation, which accompanies this exhibit, that this is a printout of the register of members on the 20th of September 2017 at 11:08 AM. Of course, this is a red herring because although the transfer took place on the 20th of September 2017, we haven't at any time after 11:08 AM on the 20th of September 2017 the register could be updated.
Well, this actually says, this page says 22nd of June 2007.
That's the date of entry of Saturn Holdings Limited.
The date of the register appears above.
Yes. If we look at C.
Oh, yes.
We look at C38. 3838, page 387. All right.
Which volume are we looking at?
So can we keep open D?
Yes.
Can we get C on top of it? Tab 38.
Slide 3.
That's right, yes. And then on page 388, paragraph 17D. So when Mr. Nye says that on the 20th of September, the copy of the register attached to the email, a copy of the share register. This was on the 20th of September 2017. We can see that we can see from D2, page 23, sorry, D1.
Age.
So we can see from D3.
Not D1.
No, so
Not very helpful, these huge volumes, to refer to the volumes.
So D2,
so D3.
D3. What page?
2763. We can see this later. This later printout shows that the docile right transfer was not put on the register until the 20th of September 2017, when it should have been put on when it acquired the shares in 2013.
Yes.
So the fact that it wasn't on the share register until 2017 is neither here nor there. We have the up-to-date register there. And that point made by Mr. Lai is terribly confusing. Not only is it terribly confusing, it's just not impartial, it's not neutral, it's terribly one-sided.
It doesn't seem to be wrong either. It doesn't seem to be wrong.
Well, it is wrong because the updated register, the up-to-date register is here.
Right. But I thought what Mr. Lai was saying was that after 2007 was a mess because Congress was supposed to have passed over the registrar function to some other entity which didn't take it up.
My lord, he may have been given a factual rundown, but the way, in my submission, the way it's read, it could have been presented in a more neutral fashion. The current register, the date of register is the one at 2763.
I'm not clear why you say that Marine Bright had the shares transferred from 2013. this is showing a transfer to Docile Bright in October 2013.
Sorry, my lord. Can you read that?
Did you say that Marine Bright had the shares transferred to it in 2013?
No, 2017. So
Oh.
Docile Bright acquired the shares in 2013,
Right.
and the transfer from Docile Bright to Marine Bright was in 2017. So the share register in D3, the beginning of D3 shows
No, you've got shares.
yes,
Yeah.
is it's Docile Bright and Marine Bright is stated to have acquired the shares on the same day. But in fact, that's just the day the Docile Bright was entered into the register of members.
Let's see.
Earlier in Lai's third affirmation, that the board resolution of the first transfer is discussed in 2013.
Sorry, say that again?
So in Lai's
Yes.
C3A,
Yes.
he says in there that the transfer from Saturn to Docile Bright is recorded.
I don't quite understand why Mr. Lai is able to say what he says at paragraph 14 about the resolutions without producing them.
Well, apparently it's not. It can't be found.
Well, how does he know it?
That's a real concern of discontinuing the setting aside the winding up order, is that we've seen that the 2017 annual statement isn't up to date. It doesn't disclose the true owner of the preferred shares. There's board resolutions missing. There needs to be an independent liquidator in charge of this company to protect the creditors. It's evident that it's simply a mess.
I have in the back of my mind, having seen somewhere, the suggestion that at the time of the transfer to Saturn, sorry, at the time of the transfer from the Saturn company to Docile Bright, no transfer was possible under the rules of the company, and that at the time of the transfer from Docile Bright to Marine Bridge, the transfer had to be to GZE or an affiliate. But I can't quite work out where I got that information now.
That's spot on, my lord. And it is. I think it's perhaps it might be the second affirmation of Mr. Lai. Which might be here. My lord, that's not contested, and it's agreed that the bylaws did originally advise that Saturn couldn't transfer the preferred shares, but the bylaws were then amended to allow for a transfer to Docile Bright, and to allow for any transfer to
Okay. We're going to adjourn for now.
Right, so the court's still good. 5 minute break. Okay.
Give us about 15 minutes. That sounds desirable.
Yes. Where were
My lords, we were talking about the we were talking about the bylaws and how they were restricted when Docile Bride acquired the preferred shares from Saturn.
Yes, and as I understood you would say, it's common ground that when there was a transfer from Docile Bride, then under the bylaws no transfer was possible. And when the transfer was from Docile Bride to Marine Bridge, the transfer had to be to GZE or an affiliate.
That's right, Marine Bright, my lord.
Marine
Yes,
Bright.
yes, yes. That's right, my lord. Yes.
Right.
And
That's what the articles provide. Is a board resolution confirming a transfer effective?
we looked into this, my lord, and we've gone through the bylaws, and they would seem to require a members' resolution to amend the bylaws. There isn't provision in there that.
So can you raise your voice a bit?
We've gone through the bylaws of the company,
Yeah.
and it would seem that the members would have to pass a resolution to amend the bylaws if they needed to be amended. Yeah.
Your
Well,
primary,
there's no discretion. There's no discretion under the bylaws for the board to overrule.
Well, if that's right, if at the time the transfer took place from Saturn to Docile Bright, no transfer was possible. Docile Bright never had good title, so it couldn't have transferred good title to Marine Bright.
Well, we understand there was a shareholder resolution amending the bylaws in 2013, which Mr. Lai, I believe, concedes. This is why it's quite remarkable that the documentation for the 2017 transfer is missing.
Mr. Mason, you brought our attention to the letter at page 2345, tab 49 of volume D2.
Yeah.
And it's addressed to Titan on Marine Bright, affirming that Marine Bright or the affiliates of GZE.
And my lord, you're looking at the letter from GZE to Titan.
No,
From
Marine Bright to Titan.
Marine Bright to Titan, yes.
What was the point of that?
My lord, this was produced by the company, so this wasn't produced by Marine Bright.
But it's a Marine Bright's letter, or book, to be.
Yes.
And it's addressed to Titan.
I'm just going to it now. Yeah. This is all addressed at paragraph 22 of Marine Bright's original skeleton, which may assist your lords.
It might. Where is
That's at tab 3 of bundle G.
yes. Where shall we look?
So paragraph 22 on page 120.
Yes. Oh, this is where I got the reference to the bylaws originally not allowing immediate transfer. Oh, no. Well, just a second. In lie 3, to which you referred us, at page 387, he describes how the board of directors passed resolutions in September confirming the first and second transfer. But what you refer to in paragraph 22 at G120 is that a special general meeting of the company passed an ordinary resolution to approve the transfer between Saturn and Docile Bright, contrary to the bylaw non-transfer provision, and a further resolution approved the transfer of the preferred shares from docile bright to marine bright. But you say at 22, see the third affirmation of line paragraph 14. But the third affirmation, of which I've just seen, of Mr. Nye, paragraph 14, does not deal with a special general meeting of the company, but resolutions of the board.
Yes, this is in relation to the 2017 transfer from docile bright to marine bright. So the special general meeting of the company was where the bylaws were amended, were in 2013 in respect of the transfer of the preferred shares from Saturn, the original owner of the shares, original holder of the shares, to docile bright. So at that stage, we know that there was a special general meeting of the company.
Where do we see that? Where's the evidence in the 2013 meeting?
So that is over the page at 386. So starting from paragraph, one can read from paragraph 6.
From paragraph 6?
From paragraph 6, but paragraph 8 deals with the mechanics.
Right. Oh, I see, yes.
Still not clear to me when the prohibition that was provided for by paragraph 8 of the schedule to the bylaws referred to in paragraph 8 of Mr. Ly's third affirmation, when that was changed to permit the transfer.
Paragraph 10, I think, deals with that, my lord.
Yes. Paragraph 8 says, at the time of the first transfer, they couldn't be transferred. Then on 22nd of June 2015, there was a special general meeting of the company to approve something called the LISCO Preferred Shares Modification Deed. And
that's apparently
included the first transfer. And in the same meeting, the company adopted a new set of bylaws whereby the preferred shares changed from being non-transferable to becoming transferable to GZE and its affiliates.
So that happened in 2015, not 2013.
Yes.
Yeah, the first transfer, the transfer was executed in 2013, as we can see in paragraph 7 at the top of page 386. But the actual resolution amending the bylaws, so the transfer was actually compliant with the company, was 2000.
Retrospectively validated.
Right.
Yes.
But then, sorry, going back to your skeleton. Paragraph 22, second sentence, the third affirmation of lie states that docile bright acquired the preferred shares previously from Saturn at a time when the bylaws stated the preferred shares were not capable of transfer, and you there refer to paragraphs 8 and 9 of the third affirmation which we just looked at. A special general meeting of the company passed an ordinary resolution to approve this transaction, and you don't give any reference to that, although it is in fact to be found in paragraph 10 of line 3. Then you say, likewise, a further resolution of the company approved the transfer of the preferred shares from docile bright to marine bright.
There should be a resolution, a board resolution of the company rather than resolution of the company.
Yes.
Sorry, which is the board resolution?
So 1, 2, 3, 4, 5, 6, 7.
Likewise, a further resolution of the
Eighth
board.
line down in paragraph 22, it says likewise a further resolution of the company. That should state likewise a board resolution. of the company approved the transfer of the preferred shares from Docile Bright.
At the time when transfers were permitted to GZE affiliates.
Yes.
So the position would be that provided, we actually need a board resolution, provided that GZE, provided that Marine Bright was an affiliate of GZE, the transfer to it was legitimate, and it didn't need a board resolution to validate it. If it wasn't an affiliate of GZE, the board resolution would be inadequate to effect it.
If there's no special general meeting to accompany it, but we don't know because we're missing documents from that time. But I mean, the primary case is that it appears that Marine Brights were an affiliate of GZE. They produced this letter, the board resolution. Were satisfied and they approved it, and no one has sought to set that aside or put absolutely any evidence before the court.
It's like Mr. Potts saying it's undisputed that they weren't an affiliate. The evidence is that they were an affiliate, and no evidence has been produced to show that they were not an affiliate.
Yeah, absolutely. Yeah, so it is slightly misleading.
Right, okay. Got somewhere.
So that was
Thank you.
That was point D of the of paragraph 102 of the claimant's skeleton. So we were then on to paragraph 102E, which is on page G33.
Where are we now?
The G33.
This is in the appellant skeleton again.
Yes.
Yes.
So it is considered that there's no evidence as to the consideration, but I've taken your lords to the sold notes and the transfer document, which show the consideration stated as being paid and received and signed and not contested.
Yes.
So there is evidence as the consideration. There's no other evidence against that.
Mm-hmm.
So dealing with point F, that it's not disputed that the value of the shares was Hong Kong 380 million Hong Kong dollars. Well, there's actually been no evidence before the court as to suggest that 20 million US dollars for the preferred shares at the time of the Docile Bright to Marine Bright transfer was significantly below market value. It's Mr. Lay's bold assertion without any evidence in support in his third affirmation, he just states that the value of the shares at the time of the transfer was 100 and let me get the exact figure, but he essentially contends that this is at C29, page 308 of bundle C. He says that the value of the shares were approximately 380 million Hong Kong dollars in early 2017, whereas they were sold for 156 million, which represents only 39% of their value.
Mm-hmm.
But we haven't had a shred of evidence to support that. It's just figures plucked out the air.
Which paragraph number? This is.
This is paragraph 23 on page 308 of bundle C.
Yeah.
It's tab 29.
Well, the only evidence that the shares were 380 million at the beginning in 2017 is paragraph 23 of Mr. Ly's second affidavit. Is that what you're saying?
That's right, my lord. Yes. And such a bold assertion shouldn't really be considered by the court without corroborative evidence in support. There hasn't been a shred of evidence. Especially for such a serious allegation. And dealing then with G, on page 34 of bundle G, the company's assertion that there was no publication of the alleged transfer of the preferred shares. Again, this is a regulatory compliance point and is inherently weak.
If the shares had been sold at gross undervalue, would the transaction act as avoidable?
That would be subject to British Virgin Islands law, which is 6 months for transactions at an undervalue. There's a vulnerability period of 6 months, but if the parties are connected, then the vulnerability period is 2 years. So it depends on whether Docile Bright and Marine Bright were connected or not, essentially, because Docile Bright went into liquidation, I believe, on the 9th of February 2017, and this transfer was on the 5th of 2019, and this transaction was in February 2017, so it was just under the 2-year mark. So if Docile Bright and Marine Bright aren't connected, even if the transaction was at an undervalue, it can't be set aside. It's only if the parties are connected, and we've had no evidence or suggestions to suggest that the parties are connected. So it's all up in the air, and really, if such serious allegations are going to be made or sustained, there should be some evidence and support without such accusations just thrown around all over the place to confuse everyone.
Yes.
Yeah. And under Bermuda law, it would be the same provisions would apply. But Docile Bright and Marine Bright are British Virgin Islands companies, hence giving the lowdown on British Virgin Islands transactions at an undervalue regime, but the same position would apply in Bermuda.
Right. Okay.
Okay. Oh, it's voidable. Yeah. So I think the word was voidable. It's void. It's not automatically void. It's voidable.
It is.
Yeah. Under Bermuda law and British Virgin Islands law.
Yes.
So, and then point G that there was no publication of the announcement concerning the alleged transfer. Again, that's an inherently weak point. Yes. So dealing with issue 3 of the skeleton, which is the judge's reasoning in his judgment at first instance. Turning to the judgment, which is at bundle A, paragraph tab 1, so and it's on paragraph 76. Yeah, so it's page 30. Sorry, it's page 29. So the Chief Justice gave a very full and considered judgment in the whole, but just concentrating on ground 3, he starts by confirming that there's no dispute that the shares were redeemed, and then goes on to state the docile bright and marine bright contention. He considers the evidence put forward by docile bright's liquidators that the transaction may be at an undervalue and may be subject to being set aside. He also considers Mr. Lye's affidavit evidence, and he directs himself to the correct legal rule. He then goes on at paragraph 80 and then gives us a substantive reason as to why he finds that Marine Bright were, in his mind, the prima facie creditor for the purposes of these proceedings, considering the register of members, the share certificate, and the transfer of shares. The company have suggested that the court should have considered Mr. Lye's evidence in more detail, but as already touched upon, Mr. Lye's evidence wasn't certain. It was very weak and it was very speculative. And in fact, it's now at odds with docile bright's contentions in the BVI proceedings and shouldn't be considered to be serious. The judge didn't have to itemize every single issue and every single page of evidence and give his findings thereon, as Mr. White's touched on in authority before. And it's entirely appropriate that the judge has referred to the strongest parts of the evidence, generally mentions the other evidence from docile bright, and come to a very reasoned conclusion. And it's completely sound, and therefore should stand.
Right.
Okay. Earlier it was discussed where the provision is in the winding up rules for a creditor to challenge another creditor's proof of debt, and it's at rule 77.
Is that the one you said you had a copy of?
That was 27.
This is the one I think George will have the answer.
Yes. So the exact wording, my lords, the court may also expunge or vary a proof upon the application of a creditor or contributory if the liquidator declines to interfere in the matter.
I'm sure we could find them, but I think actually it would be helpful if we had a copy of Rule 27 and 77.
We can send a copy to, oh, you've got.
relation to Rule 27, which of the three premises would you invite the court to rely upon?
Well, I think none of them, but what it actually says is where a petitioner from order that a company we wound up by the court is not entitled to present a petition, or whether so we're entitled not where 1, 2, or 3 apply. You would, I think, say that we may get to the position where the petitioner is not entitled to present a petition.
That was the point, my lord. Yeah.
See.
Okay. Right.
My lords, I did find the part in the transcript where Miss George referred to the letter.
Yes.
But I don't think there's much point in me taking you all there, because all she does is refer to the letter. But the point is that it was raised at the first hearing that the Marine Brights were contending that they were that everything was in order and that they were an affiliate of GZE for the purposes of the transfer. So that was brought up at the earlier proceedings as well. And that's at F tab 62, page 224, between 224, sorry.
Right.
And that's at lines 9 to 13.
Mm-hmm.
224 line.
2224.
224.
Before you leave Rule 27, if you were to proceed on the basis that the petitioner is not entitled to present a petition, your client were to be substituted, are you in this context relying upon re opus for establishing that your client is in fact a petitioner? In other words, on the prima facie basis?
My lords, we believe it would be more than a prima facie case. It would be on the usual basis that the court is satisfied by either by way of a statutory demand or otherwise is listed in the act.
You have to be satisfied that you are in fact
yes
a member.
Yes.
Yeah.
Yeah. Yes, my lord. My lord, and that's the end of my submissions. Really, just that that Marine Brights are clearly the majority creditor, and that the submissions put forward by Docile Bright cannot be considered seriously, especially when there's clearly a motive for Docile Bright to put forward untruthful submissions and contend that it's the major creditor to try and support the company and support the board of directors in convincing the court that a restructuring is more appropriate. The Marine Bright are content that the liquidator should remain in place to protect the company. We've seen that we can't even keep the register of members up to date or report properly in its annual reports. And Marine Bright are really concerned that if the liquidator disappears, that they won't be sufficiently protected at all. So that they would really urge the court to keep the liquidator in place, and hopefully the court will see that that they are in fact the owner and of the preferred shares. And unless I can assist any further.
No, there is one matter which I felt I might need Mr. George's assistance. I understood you to say, at some stage through your submissions, that you didn't have instructions as to whether or not Marine Bright would wish to be substituted as a petitioner, but you then spoke to Ms. George and appeared to obtain instructions. I want to be satisfied that Ms. George was in a position to give you such instructions if you first told us that you hadn't got any.
I didn't believe that we had instructions, but Miss George confirmed that we did. We
That is right, is it, Ms. George?
Yes, my lord, yes. Our client has indicated that if the petitioner is unable to proceed, if he's found not to be entitled to present the petition, that they would be willing to be substituted, to apply for leave to be substituted as petitioner.
Right. Thank you. Right. Thank you very much.
Thank you, Lord.
Now, what time have we reached now? 25 minutes to 6. Mr. Potts, are you still here?
Well, I'm here. I'm not at a camera, but I can hear you. You can hear me?
Yes, I can hear you. Yes.
For personal reasons, I would be very grateful if we could finish today.
Right.
I'm on a British Airways flight this evening to London. But if your lordships were not willing to sit a bit longer, then options might include putting in a written reply within a short period of time after the hearing today, or possibly even participating by Zoom tomorrow from London, if your lordships are going to accommodate doing that. But I'm happy to give it a stab now and try and deal with the key points in 30 minutes.
Yeah, good.
Mm.
I mean, how long do you think you'll be?
That's 30 minutes.
Well, I mean, it's one of those difficult. I'm sure I have clients who would like me to be 2 or 3 hours, given how many points you've ventilated. But for your lordship's assistance, I would prefer to try and answer any questions you have and just refocus the debate on what I see the key issues.
Okay.
Because there's a whole catalogue of points one could cover, but it's time consuming.
Well, one possibility is that we hear you already and give you leave to find something in writing.
Further.
So, what you'd like to say?
I would be very grateful for that opportunity.
Yeah, we are entitled to it. The reason
Do you mind if I just spend one moment reorganising myself so I can get a bit closer?
Yes, sure. Okay, you know, of course, please do.
Thank you, my lords. So far as round 3 is concerned, and my own friend Mr. Mason's submission on behalf of Marine Bright, I really don't think it's going to be a productive use of the court's time now for me to try and address those points, but I'll invite you to look again at the skeleton in support of the appeal, the grounds of appeal, and the evidence before the court.
Okay.
As I said in opening, we do respectfully submit that it is, in the end of the day, irrelevant to the analysis that's really the heart of the appeal on grounds 1 and grounds 2 in particular, because if we are right, and if the Chief Justice was wrong as to the arguability of a dispute,
then it knocks out the petitioning creditor, the Cayman Court of Appeal and GFN and all the authorities that are canvassed in that line of authority. It knocks them out, but for the conceptual possibility that's been raised for the first time just now, as to the possibility that Marine Bright in that scenario would have wanted to make an application for permission to be substituted. But just pause there analytically. There was no application for substitution before the Chief Justice, so it's never been considered at first instance. It's true that the Court of Appeal has, in a sense, wide powers of a first instance court, but we don't have a respondent's notice from Marine Bright as an interested party. We don't actually have any application before the court. We have an off-the-cuff intimation that there might want to be an application. And as your lordships, I think, have appreciated, if in an ordinary first instance scenario, another putative creditor was applying to be substituted in place of a petitioning creditor, you would have to have a fully ventilated debate as to whether they in turn had standing to be a creditor or whether their claim was disputed. And in this case, all we have from the Chief Justice is an acknowledgement of a dispute and not an actual finding or resolution of who is on the right side of it or the level of arguability, but his conclusions, which are really summary in nature, that they have prima facie standing to claim to be a creditor, notwithstanding the disputes from the other parties who appeared at first instance, and who I should say are not here today represented to make their case on that issue.
Chief Justice might have used that form of words with Arcos in mind. Sure he did.
He did because the debate that was put to him, it was framed in such a way that it wasn't a substitution application. It was suggested to him that for the purpose of weighing up in the exercise of discretion the views of creditors or contributories, it would be sufficient to say that there was a prima facie claim to be a creditor. But that doesn't really work if that very claim is the subject of a dispute. And if you don't adjudicate the dispute, you can't work out what weight to attribute to the party who's supporting the petition vis-a-vis the party who's opposing the petition, claiming to be the true or rightful owner of those particular shares or that claim. In a sense, that's where we end up on our appeal, which is not to seek to persuade your lordships today that what the judge should have done is given weight to Docile Bright's point of view. We obviously know that Fame Dragon were a contributory, they were opposing, Docile Bright were opposing. But we're essentially saying that what the court should have done is treated all of those supporting and opposing views as effectively immaterial to the issues before the court. They didn't lend any additional weight or provide any further value to the questions actually before the court. Now, as it happened, we respectfully suggest once he went down the path of seeking to attribute weight, he was essentially fortifying a conclusion by reference to the wrong test and the wrong conclusion on this issue. But as I say, I don't want to, in a sense, I prefer your lordships did not get bogged down with the detail of this issue, save to acknowledge that even on the evidence, Mr. Mason throws a number of epithets at Mr. Ly's evidence and suggests that it's not to be believed, it's incredible, it's not corroborated. In the same way, Mr. White has sought, both at first instance before your lordships, to criticize the evidence. But all of that illustrates, in my respectful submission, the triability of the issues. One can well imagine if one was going to put yourself in the shoes of a Hong Kong judge trying the disputes, the sorts of lines of cross-examination that an advocate might wish to explore. But on the primary issue, the first instance, it was the Tallington standard with low threshold of arguability. And so far as the supporting interested parties or the opposing parties are concerned, they essentially nullify each other given the state of the evidence. And the judge on that issue, in our respectful submission, simply didn't engage with the issue of the evidence or its totality, properly.
Just on that last question, I know exactly what you say in relation to not engaging with the evidence. And in particular, you say that he didn't really engage with lie to, you referred to it, but didn't really deal with the round robins. He only dealt with the first round robin, and didn't deal with the points made in Appendix 1. What appears to have happened to Judge is that in relation to lie 2, you said that Mr. Martin would deal with it, and Mr. Martin said, Mason, sorry, Mr. Mason.
Mr. Robinson. Mr. Robinson.
Mr. Robinson. Yes, sorry. You said, I don't know if Mr. Robinson will deal with it. And Mr. Robinson said, well, of course, your lordship will read lie 2. And that was it.
Well, your lordship, in a sense, I was flattered that you described my effort as feeble. In a sense, if it was feeble, I'd probably live with that. But if I can try and give you a flavour of the hearing and how it unfolded. The first observation, it was a Zoom hearing. So everyone was participating by Zoom. It was scheduled for 2 days, but we had 4 participants, 4 active sets of lawyers participating. And if you look at the transcript, you'll see that a little bit like this hearing, we ran out of time on each day and we had to try and find time. Mr. White was the petitioner. So he presented his petition for most of the first day. I got a short window of time at the end of the first day to essentially deal with my response, opening it. By that time, the judge had not engaged with the time summons application, which was on the papers, in theory, still being opposed. And I don't know if it will help just to look at the skeletons at first instance, my lord. But can I ask you to pick up volume E? And just pick up my skeleton at first instance, which you'll find starting at page 3629. Just while we look at it, there's a point that my learned friend Mr. White made, which wasn't a fair assessment of our position at first instance, because if you look at paragraph 3 on page 3629, we, on behalf of the company, invited the court to dismiss the petition in light of the dispute between the parties. Alternatively, the company invites the court to adjourn or stay the petition pending a final and binding determination of the Hong Kong proceedings in circumstances where Hong Kong is the most appropriate forum for the dispute between the parties, which is substantially governed by Hong Kong law. So it's not correct to say that I ever said to the judge, at the bottom of 3629.
I'm sorry, my number is out, it's 3604. Okay, sorry. Okay, we'll do it together. Sorry, go start again.
I'm sorry, my lord. So at 3629, paragraph 3, we set out in summary the company's position. We invited the court to dismiss the petition in light of the dispute between the parties. Alternatively, the company invites the court to adjourn or stay the petition pending a final and binding determination of the Hong Kong proceedings.
Yes.
Now, I mention that because Mr. White seemed to suggest that we'd only ever taken position 1 and that we're somehow a late convert to the alternative. And that's not a fair characterization either of our written submissions or our oral submissions. I was sufficiently arrogant that I actually thought we were winning the case when the judge said, well, what's the right result?
Yeah.
So when I ended up saying the right result is you dismiss the petition, but it's open to your lordship to adjourn it pending Hong Kong proceedings. I wasn't conceding anything. I was simply saying our primary case is the one which I think we're going to win on, but the alternative case is still that solution for the court in light of complaints about dispositions.
Not assume from what the judges say or ask that then it is going to win or lose.
No. Well, and I'm sure it got lost in the Zoom cyberspace translation. I probably just misunderstood what his tone of voice.
That's why face-to-face meetings are rather better.
But then going to the question of the evidence, you'll see that we summarize the case in these first few passages of the skeleton. But you get to the summary of what evidence was before the court at page 3635. And at 3635, we rehearsed what evidence had been before the court as at the last hearing in February 2020, paragraph 13. And so we rehearsed the fact that there was Mr. Shu's, Mr. Zhang's, Mr. Lai's first affidavit, Zhao Bing, and second and third Zhao Bing. Now, just for what it's worth, footnote 26 of my skeleton, I had identified the fact that the court had struck out certain passages of Mr. Zhang's second affirmation, but I actually invited the court, one might say cheekily, but I invited the court to actually admit some or all of those paragraphs into evidence in circumstances where by the time of the actual hearing, there can have been no real prejudice to including them. And it's quite important to bear that in mind, because some of the complaints about, for example, the absence of any evidence with respect to the complaints about a disposition, for example, the actual response had been struck out by the judge on the terms that no further evidence should be put in.
But you made that application to the Chief Justice?
I'll come on to that. So it was footnoted as a point in my skeleton, saying, look, you struck out that evidence procedurally. It's true we didn't appeal that, but I was trying to explain to the court, time has moved on. We're now a year and a half later. Essentially, it would be wrong to disregard it. And then at paragraph 14, I acknowledge the fact that since February 2020, the following additional affirmations have been filed and served and are in the hearing bundle, subject to potential arguments as to admissibility. And so I refer to Mr. Lai's second affirmation of Mr. Lai.
Yes.
And then I refer to the fact that there were these unsworn and undated 4th, 5th, 6th, and 7th affirmation of Zhao Bing, as well as the signed affirmation but unsworn of Mr. Li, director of Toprise Global Limited. Now, I also refer to 15 to the evidence from the Hong Kong solicitor updating the court on the Hong Kong proceedings. Now, because when I dealt with the company's response to the petition, there was a degree of uncertainty as to whether Mr. Lai's affirmation, which by then had been filed by Fame Dragon, was in or out, given the time summons debate. It certainly made sense for me to present my case principally, although I would certainly not characterize Mr. Lai's evidence as ever being treated as peripheral. But my principal focus was on actually arguing the case by reference to the totality of the information that was available to me. So I then spent quite a long time taking the judge through all the points as best I could that emerged from all the evidence. But when I got to the end of the hearing, recognizing there were time constraints and obviously case management constraints, I said, look, Judge, I know you're going to have to reserve your judgment. I impress upon you the need to review the totality of our skeleton argument, as well as Mr. Lai's second affirmation, upon which we wish to rely, subject to the fact that Mr. Robinson is coming up next, and he in turn will deal with Mr. Lai because he's put it in on his time summons. As it happened, Mr. Robinson, who's not here today, I'm sure he would say to the court that his point of view was, well, given the time constraints of the hearing, it didn't make sense for him to try and rehearse the detail of Mr. Lai's submissions, because at that point in time, he sought to put it in, and it was essentially agreed that it was in. So when we essentially adjourned the hearing, we were all under the impression, as reflected in the judge's judgment, that Mr. Lai's second affirmation was in, that all the issues had been canvassed in submissions as well as we could in the time available, but that the judge would review everything at his leisure. And we all have experience of the Chief Justice being diligent in his pre-reading, but diligent also in his post-hearing reading. So
when was the time summons resolved?
I think, regrettably, it was one of those Zoom hearings where no formal order was drawn up. And whether the judge approached matters de bene esse as the hearing unfolded, or whether the judge realized it was such a silly ground of opposition, given the passage of time, that essentially it was not. But in the same way, we had these complaints, which he also never resolved, as to the very late filing of what we said was highly prejudicial evidence in terms of all these Zhao Bing affirmations. So as we approached that hearing date, we'd already been criticized by the judge for trying to put in further evidence. And we then suddenly got hit with the seventh affirmation, which tries to introduce all this additional prejudicial material about the current alleged state of insolvency and the current alleged post-petition dispositions, all of which we say analytically are irrelevant. They are irrelevant to the question of the dispute. So not only are they legally irrelevant, but they are highly prejudicial in circumstances where there was no permission granted for that evidence to be put in by way of a timetable and no proper opportunity for us to respond to it. So we just didn't. Now, the judge, as part of all the other rather summary approach to this hearing, didn't catalogue and then adjudicate in writing on every bit of those procedural and evidential conundrums. But it was certainly an enormous surprise to certainly my clients to then read a judgment which looked like it had been written at a point frozen in time as being just a competition between Mr. Zhao's first affirmation and Mr. Zhang's first affirmation. And it completely ignored the fact that even Mr. Zhang's first affirmation had been corroborated and supported by Mr. Lai, albeit in a short affirmation. And it completely ignored the fact that Mr. Lai had then come along, albeit in an affidavit filed by the supporting or the opposing contributories, the opposing creditor, to articulate in even further detail what had already been articulated by Mr. Zhang. Now, yes, there's a degree of misfortune, procedural misfortune in all of those series of events. And in a sense, I, as counsel, am imperfect, and so perhaps have to take my fair share of the blame in not taking another 2 hours to take the Chief Justice through the detail of those appendices. But if I may say so by way of self-defense, we were focused on the low threshold of arguability. And the judge, if you go back to the GFN analysis, it is true that there are exceptional cases in which a court, in a winding up court situation, a company court, can say, look, it's an arguable case, but this is now going to be one of those exceptional cases where essentially we try it. But if you're going to try it as a company's court, you still have to then apply your mind to the question of whether or not the parties realize that's what's happening. Has there been proper discovery? Has there been an opportunity to apply for cross-examination? And the advocates have to come to court knowing that you're dealing with a trial of the dispute, as opposed to simply the very low threshold of arguability. But we all approach this as a low threshold of arguability. And with that all said, I mean, where I really want to, in a way, end up in reply, is to remind your lordships of the irrelevance, we say, of all of that background noise about bona fides or credibility. Because that's all the baggage you get at a trial when you are criticizing witnesses in cross-examination. Finsoft, if it's just helpful to look at Mr. Justice Harmon's judgment in the Finsoft case, just to illustrate the point, I want to make sure your lordships remember when you reserve judgment. Can I just ask you to turn that up in the H bundle? You'll find Finsoft.
So sorry, which tab is this?
Just trying to find it myself. Which tab is Finsoft? Sorry, it's tab 17, my lord. Tab 17 of bundle H. This was a judgment of Mr. Justice Harmon. And just a couple of observations about it, for what it's worth. And I did make these observations at first instance. You'll see from the top of the page at page 737 that the matter was heard over 3 days in March 1991, 26, 27, 28. And it related to a petition that he presented on the 18th of February, so only a month or so prior, and related to a petition that alleged dishonor of a promissory note presented for payment on the 7th of January. You'll see from the head note at 737 that the company had made a positive application to have the petition struck out as an abuse of the process of the court, alleging the promissory note had been obtained by means of fraudulent misrepresentations. So just pausing there, it's not a company defending a petition at the hearing of the petition. They're taking the positive step of applying to strike something out as an abusive process. But the headnote acknowledges that the allegations of fraudulent misrepresentation were first raised by the company in a writ action against the petitioner commenced on the 15th of February 1991. Now, the headnote says if there was a substantial dispute as to the debt upon which the petition was founded, the petition would be struck out as an abusive process of the court. It was irrelevant whether the debt was disputed in good faith. On the facts, the disputes raised by the company were not substantial. The late stage which allegations of fraudulent misreps had been raised and the evidence the company was probably insolvent suggested the company was looking for any defense to avoid payment of the promissory note, where the petition would not be struck out. Now, you'll see if you look at page 738, the first section of the judgment, that this looks like it was an extempore judgment of Mr. Justice Harman, because he says this is an application brought erroneously by notice of motion, treated as an ordinary application by a document in petition so-and-so. Petitioner is called Finsoft Holding. The company seeks to have that petition struck out on the grounds of abusive process. That claim, based on abuse, having been added by amendment permitted by me yesterday, although the amendment was mentioned by Mr. Sibery, the company, on the first day of the effective hearing of this application on Tuesday of this week. Now, he then has that passage, which actually we say is correctly framed as to what the actual issue for the court is there a substantial dispute? You'll then see, if you were to review paragraph 740, 741, 742, the rather preposterous nature of the allegations of fraudulent misrepresentation in response to a promissory note, which in a sense is as good as cash. Now, you'll see at the bottom of page 376 of the bundle, being 745 of the judgment, at the bottom of the page, so 745I, I'm faced with the question, do these allegations in the statement of claim, coupled with evidence and affidavit before me, make a substantial series of issues of facts which to raise a bona fide dispute going to payability of this debt? And then he goes on to say at 377 letter E, so 746E, seems to me in these circumstances, there's no possible arguable case. The representation in the first memorandum was operative and proper to be relied upon when the agreement was signed. Further, there's no representation either in the information memoranda about indirect interest and so forth. Now he goes on to say, essentially, that as a matter of analysis of the pleadings and the evidence, it is not properly arguable, it doesn't meet the threshold of arguability. Now, when he then gets to the passage at page 749 of the judgment, so page 380 of the bundle, let's just below letter A, he says, it follows that I'm totally unsatisfied that the disputes raised here are substantial. They seem to me to be fanciful, bearing in mind these serious allegations of fraud were never raised until service to the statement of claim. Now, at this point onwards, in Maritime Submission, what he's doing is he's essentially providing additional gloss stroke obiter comments that fortify his analytical conclusion on the issue of the dispute. He's already concluded there's no objectively arguable dispute, but he's finding comfort in the fact that he thinks there are some indicia of lack of good faith, including the delay. And then you'll see just above B, in fact, they weren't raised in a letter before action. They were never mentioned in the discussion between Peretti and others, including the English solicitor and petitioner. And the late raising of the allegation seems to me show they're the result of dredging about for any form of defense. He then says, I believe I'm entitled to bear in mind that it appears on the evidence that the company is very like solvent. I accept Mr. Sibley's submission that insolvency is not an issue here. What is an issue is whether the creditor is a true creditor in the sense of having a debt not disputed upon substantial grounds. Nonetheless, an action insolvency would give likely motivation. Now, the point I tried to make to Chief Justice, in which I would impress upon your lordships, as I made in opening, is that analytically, this case involves the objective question, is there an arguable defense and counterclaim of the sort being run in Hong Kong? All the rest of it is just window dressing. It's prejudicial. And going back to the sequence of events with the evidence, lie 2 sets out the objective evidence, as in fact we suggest did Mr. Zhang's affirmation. But Mr. White, as he's done on this appeal, has sought to engage in the sort of exercise that is ultimately unhelpful because it's prejudicial. It's rubbishing affidavit evidence in the absence of cross-examination. And yet actually, if the judge had fully analyzed the evidence and fully understood it, he would have acknowledged that it's at least arguable. But that's, in a sense, it is why we keep on persisting in the proposition that this late evidence, this prejudicial evidence, where someone's trying to insinuate that the company's board, the board collectively, made up of responsible professionals, is somehow acting in bad faith, mala fides. Even all those allegations could only ever properly be tested at a trial. So I do, as I say, take my share of the blame for not having done a better job before the Chief Justice, but I do not accept that he was entitled to simply ignore evidence, and nor do I accept it can be properly argued that by ignoring it entirely, he is therefore to have been taken as implicitly rejecting it for any rational reason.
I mean, it's unfortunate, maybe an unfortunate consequence of those Zoom theories, which is one of the reasons why some of us are not keen on them, and it's much better if we don't have to have them. The reason for my question is that it seems prima facie slightly unfortunate to criticise the Chief Justice for not going into lie 2 in any detail or in like manner as we have done it over the course of the last few days in circumstances where that exercise wasn't done before. But it may be that the answer to that is, well, that's it may be, but that doesn't alter the fact that the evidence is before him. Even if not, lie 2 was very much before him, he was invited to read it. The fact that there may not have been specific submissions by reference to specific paragraphs is neither here nor there. If in fact, when we look at it sitting in a darkened room, it shows that there is a viable defence.
My lord, I mean, we certainly aren't pursuing the appeal with a view to making an ad hominem attack on the Chief Justice.
No, probably not.
But again, it would. I mean, the transcript itself is unreliable because it was done by Zoom. If you look at the index, the word inaudible is the largest sort of word in the index in terms of the number of references.
The transcript of this hearing may be done by Zoom, since there seems to be something amiss with court smart.
But the consequence is you can't place too much weight on what the transcript reflects was said before the Chief Justice. Yeah. But certainly I do recall doing my best to explain to him the fund flow analysis, join the dots on the evidence as to the connectedness between the various parties, as well as trying to explain the totality of the case as being put in the Hong Kong courts in the statement of claim and so forth. As I said, it was no doubt my own arrogance and imperfection that I was left with the impression that once you showed the Chief Justice the fact that the other side have put in a defense in which they are suggesting that key documents must have been forged, and they've made an application for security of costs that's premised on the case going to trial, it would have actually been a waste of the court's time to go into the level of detail that we've been provoked into going into in this appeal, in light of the way in which it's been argued by the other side and accepted by the court. So again, I apologize in the sense that I'm the source of the problem. It should not be held against the client that the result is that this evidence is utterly ignored. It's not analyzed. There's no reasoned judicial building block to reach the conclusion that this board of directors have run all of this essentially in bad faith. So I would impress the court that the right answer is it's a disputed debt. Now, my learned friend, Mr. White, just to finish off in the time available, if I may, very quickly, it was somewhat Kafkaesque, and I use that word now twice, but to introduce, in response to your lordship's questions of yesterday, on the one hand, an acknowledgement that the petition has to either be dismissed or stayed in light of the dispute, but then to suggest that in the absence of a petitioning creditor with a debt, this court of appeal, should of its own motion wind up this company or order that the winding up order be upheld on the basis put forward. Because part of the reason this company is in the ongoing difficulty it's in, particularly with respect to the audits, for example, is because of the fact of the pending petition. It has been unable to recapitalize or generate the investment it needs. It's been unable to recycle the listing, which in itself is a valuable asset, because of the fact of the pending petition. So it is almost perverse to say the petition, if we're right, should have been dismissed. But because the company looks like it's in difficulty as at today's date, the court should wind up of its own motion. And I would say that point was not advanced below. It's not the subject of a respondent's notice. We've had no proper opportunity to deal with it, to come to this court with the totality of information you would need today to form that view. But in any event, when you look at those cases, and I speak having had the privilege of being in the Kinggate case, they are utterly exceptional cases. It's actually almost remarkable that the courts have accepted the inherent exceptional jurisdiction to wind up a company of the court's own motion. Kinggate was a truly remarkable case. And the reason it was remarkable was, first of all, Kinggate Management was a hedge fund manager. It was a hedge fund manager for the two Kinggate funds, which were the two of the largest feeder funds into Madoff. When Madoff, as a Ponzi scheme, erupted, the Kinggate funds went into liquidation, and their sole purpose was to effect asset recovery. Kinggate Management had no purpose because it had no funds left to manage. The directors resigned, and no directors could be found to replace them. So you have a directorless company for many years, which was in suspended animation. It was only being kept alive because the shareholders of the company were targets of the liquidators' litigation. Provisional liquidators were put in place. Nobody pursued the petition. Everybody, as the judgment reveals, everybody was agreed it needed to be put into liquidation with the official receiver because there were no funds to fund a liquidation. The only asset it had was an insurance policy which was available to satisfy claims if satisfied against the company. So it had to be in liquidation to trigger the right of recovery. Everybody was agreed it had to be put into liquidation. That's why there's this emphasis in the judgment on the fact there was no opposition and no prejudice to anybody not before the court. It was unanimous that it should be put into liquidation. The problem was the petitioning party, the company, had no standing to pursue the petition. The provisional liquidators had no standing to pursue the petition. None of the creditors were in a position to pursue it and didn't want to, but they wanted a proper legal foundation for the court to wind up the company. So we found the inherent jurisdiction. And similarly, the public interest petition, my learned friend showed you from England, you had a public interest petition, and then you had the directors who looked like what they were trying to do was avoid the trial, to avoid the public scrutiny of all of their misconduct, coming along and saying, well, the company is now insolvent, it should be put into liquidation. The Secretary of State was saying, well, that's not right, because we still want a trial of our petition to establish the allegations of wrongdoing. Court decided, well, inherent jurisdiction to wind up. This judgment is enough vindication in the public interest in itself. To apply those exceptional facts and that exceptional jurisdiction to a case of this sort, which is at the end of the day, a disputed debt petition, would be quite wrong in my respectful submission. And it would be procedurally and substantively wrong. One scenario that, in a sense, nobody is asking your lordships to deal with, and if you go back to the grounds of appeal, you could have had a case where the right outcome is for the Court of Appeal to remit matters to the first instance court. Nobody's suggesting that is a helpful course of action in this case, subject only to that possibility your lordships have in mind, which is if you felt there was something in the passage of time or the prejudice or the balancing act, one would simply adjourn or stay the petition. Because in that sense, if you were to do that, one would imagine that it would still be the first instance court that would deal with the revived petition, if it ever were to be revived, after the conclusion of the Hong Kong litigation. But our primary case is that after 2.5 days of appellate argument, there is an arguable dispute here that satisfies the low threshold of arguability, such that the order the judge made was wrong and should therefore be set aside. with the consequence that the liquidated should be immediately discharged or their appointment set aside. And we do say that the petition should be dismissed by this court in the alternative, stayed or adjourned.
Thank you.
Can I assist your lordship any further?
Thank you very much.
I personally would prefer not to put in any reply submissions in writing, but I do have clients who are very anxious that certain points that were canvassed
Yes.
be dealt with. So if I could ask the indulgence to put in a short written reply within 7 days, if so instructed,
Yes.
I would be grateful for that opportunity.
Yes. And myself, I think we have, we need to hear, but if you think that, if you or your clients think that you could do that, you are limited to do so.
There's just some minor points. For example, there's that issue about the Mr. Ly's comments about the available cash in the company. Mr. White said, well, it's misleading because it wasn't just cash. I'm sorry?
Don't tell them to be now.
No, but points like that. I know that the clients were keen to address your lordships on them.
No, well, I'm giving you the opportunity to do that.
Thank you. So would 7 days be
Yes,
acceptable?
yes.
Okay.
It will not surprise you to learn that even after 7 days, the judgment will be reserved, and not least because we're sitting for 5 days next week. We will, of course, be conscious of these proceedings. We will endeavour to give judgment as soon as possible. There's quite a lot to work through. We're very grateful for the submissions that we have received.
My lord, I have a transcript reference which may assist. As Mr. Foss indicated, there isn't an order on the time summary.
Yes.
But I can point you to where it is dealt with by the judge.
Yes,
the transcript. And it's bundle F,
Yes.
tab 62.
Yep.
And it starts at page 214.
214. 214.
214. And the line reference is 24.
Right.
And it goes through to 250.
Yeah. Right.
At line reference 23.
And what happens in those rather lengthy pages?
215. 215. It's actually a short section.
One page.
I'm so sorry. I thought you said-
Well, this is the end of my submission.
Yes.
And the judge indicated that he was minded to admit the evidence of Mr. Lye. And I responded that I was pragmatic on that point. With perhaps some irony, the judge noted that it's best not to shut down evidence because it leads to appeal.
Because
It leads to appeal.
There you have it.
Well, that may show an element of wisdom.
To give you some context, though, Mr. Potts begins his submissions after that, at page 229.
Yeah. Right. Okay. As I say.
Thank you very much, my lords, and thank you, Mr. Quaylo, for